Oh, I pushed the wrong button. Okay. You good? Clerk? No, I don't care about you. I'm the clerk. You have something to write on?
Yeah, I forgot that I could just write on that sheet.
Okay. All right. Okay, we'll open up the public hearing on 1406 and hear from the prime sponsor, Representative Reed. Good morning, Representative Reed.
Good morning, Mr. Chair, and thank you, honorable members, for welcoming to your committee. For the record, my name is Ellen Reed. I represent Newmarket and Newfields. And before you, I have a bill 1406 that would effectively ban the pricing of goods and services on the basis of gender. You may have heard this phenomenon called the pink tax. Not to be confused, there's some confusion because there's a lot of different ways in which women spend more just to live than men, and sometimes it's confused with the idea that there, in some states, not here obviously, there's a tax on menstrual products. This is not that. This is literally pricing. For example, the go-to example is Gillette makes a black razor. It is black and silver, and it costs $4. The same exact razor in pink costs $7. That is gender-based pricing.
So this is a Barbie tax.
A Barbie tax, if you will. Yes. And there are 2 states that have passed similar legislation. This is drawn directly from one of those functioning laws that currently exist. So I've known about this phenomenon for a while. It was about a year ago that I kind of got up in arms over it because I went to Rite Aid to buy a small pair of like manicure type scissors, and I was unwilling in the manicure area to pay the $10 that the scissors were priced at. And then I had the genius idea, knowing that this was a phenomenon, to go over to the men's section. And wouldn't you know, not only a pair of scissors, but a much better quality pair of scissors cost $4 instead of $10. And I was just so mad in that moment. I'm like, I'm putting this in next year. I'm definitely doing it finally. So that's my personal story on this. So on average, and this is a very well-studied phenomenon, on average, products that are identical in cost of manufacture, in ingredients, and in materials cost 7% higher when they are marketed to women for only the marketing process, whether it's the color of the packaging or what have you. But that's average. On the low end, you have 4%, but on the high end, you have as much as double, or even more in some particular cases. I've given you a handout where you see a number of examples. My favorite one, by the way, if you look at the calculators, you can't see, but the darker looking calculator has pink buttons. And you can see the price differential there for the same exact calculator that has pink buttons rather than white buttons. So because of that, it is estimated, now this is from 1994 data, women spend $1,350 more per year to just exist than men. However, that's 1994 dollars. In today's dollars, it's closer to $2,400 a year. A woman spends more just to buy the same types of things, shampoo, soap, what have you. This is, by the way, not including actual sex-based products. So for example, things like menstrual products or what have you, that would not be gender-based. That would be sex-based because you're actually using something that men would never use. But this is just the difference in how it's marketed, with all other materials and costs being the same. And what that $2,400 per year means is that on the adult consumptive lifespan of the average woman, women are spending $100,000 more just to live during their consumptive adult life. So as I said, 2 states have already banned this pink tax, this gender-based pricing. The bill before you repeatedly exempts anything that doesn't have to do, so if it's, you have to compare the cost of the actual manufacturer or the cost of the service, the time it takes to give the service, the difficulty of service, if it's a service, the ingredients, everything has to be taken into consideration so that it is only the gender that it's marketed to that is the difference. And I guess I'll just kind of I don't think I have a lot of opposition in the room other than the AG's office, who will tell you that this will, anytime you pass a law that makes something illegal, they have to potentially do some more work. But, and I understand that. But the arguments that I can foresee is, well, isn't this the free market? And I mean, yes, but is it free when, so the idea of the free market, and it's kind of oversimplified because anybody who's taken more than one economics class can tell you that it doesn't just always boil down to supply and demand, but the idea is that those are free forces that are able to negotiate with each other freely. But the problem is when you have an industry that sees that they can prevent any other options from existing for the demand side gets hamstrung and they don't have any other choices. So for example, and I hate to bring up a triggering example, but it's probably the most recent and famous example of price gouging was during COVID, when there were people who were stockpiling toilet paper and stockpiling hand sanitizer and then charging like $50 for a bottle of hand sanitizer in the beginning days of that. So we kind of universally agree that that's kind of egregious behavior. But that, in effect, is what these industries have been doing across the board, because it's effective price fixing. They know that if they don't provide any lower cost or more fairly priced options, that the demand side has no choice but to pay for those things. So I guess I'll open up. Oh, and the last piece of that is we do regulate that type of behavior, right? We do say that you can't discriminate on the basis of sex or gender in commercial activities like housing or employment. You can't discriminate on the basis of sex or gender for commercial public amenities. So I think that it makes sense that we say, actually, if it costs you $1 and you're charging $2, then it shouldn't matter whether you're selling to men or women. I think that's just kind of common sense, and I'll take questions.
Representative McHugh.
Thank you, Mr. Chairman. I have 2 questions, both very, very simple and not substantive. But on page 2, line 20, where it says different price for 2 goods, shouldn't that say 2 goods or services?
You are correct, Representative, and I'm happy if the committee sees fit to want to work with this bill in hopes of finding a version that passes. I'm happy to work with the committee to prepare that.
Okay. The second one is a little harder.
Oh, I apologize, Representative. I think that, no, you're right. I was thinking the previous section addressed services, but yes, go ahead.
Okay. And that is, shouldn't this bill have an appropriation attached?
An appropriation for the
Attorney
AG's?
General's office. If you look at the fiscal note, it says, does this bill provide sufficient funding to cover estimated expenditures? And the answer is no. And then on the next page, there's estimated costs for personnel. I don't know that 3 people would necessarily be needed, but I think the estimation certainly for an additional person is probably not unreasonable, and therefore shouldn't there be something to cover that?
So the 3 salaries given in that, as it stated, was just an example of what those salaries would be, but the department did not come back and say it would cost them a specific, amount of extra labor hours. So if the department were to give us an idea of how much extra they would want, or just even a ballpark to enforce it, then yes, I'd be happy again to work with the committee to amend it to put in appropriations for 1 extra staff person. I'm sure that the representative, but the person behind me that's from the AG's office will speak more in depth to that.
Thank you.
Representative McHugh.
Thank you, Mr. Chairman. Thank you for taking my question, Representative Reed. I often have my razors stolen for that very reason. But I will ask you just this simple question. Can anyone buy any product from the top or the bottom row freely without restriction now?
Yes, and I kind of anticipated this question, and this kind of touches on a much broader subject that I want to make sure that we focus on this bill. But what you're really asking is, what is gender? And gender is the set of
No, I wasn't asking what is
if you
gender,
would
but
allow me
thanks.
to
Let her go where she wants to go.
the thing is that I'm here in a skirt and makeup today, as are many of the women here, because we grew up in a society that told us that's how we are expected to appear and present ourselves. And the gentlemen here are wearing suits for the same reason. And with that societal pressure, I mean, I personally would love to see a world where that ended, where there's no more expectation placed on people for how they appear, for their characteristics, for their roles in society or aptitudes based on their body parts that they were born with. However, I'm not trying to go after that larger concept. I'm saying that if we're going to have that societal pressure and we're going to say that people are expected to behave a certain way, then we can't say one half of those people who have this expectation have to pay more.
Further question, may inquire.
Thank you, Mr. Chairman. Thanks for taking a quick follow-up. It seems like it kind of corrected itself in the toothbrush market. I tend to stockpile toothbrushes. I like to have a few of them. And that doesn't matter what color they are. They're all about the same price. I think I've currently got a orange one and a purple one, and sometimes that confuses Julie. She takes the purple one, thinks it's the more feminine color. In fact, reminder, that's my toothbrush right at the moment.
Right. So you can say that as of this moment, tooth care is not a highly gendered market, but it goes there. Like I said, I gave you the example of the calculators, but I'm not sure if I included the picture or not when I was looking through all the pictures. I didn't want to give you 50 pages of pictures, but Dukalax has a blue box and a pink box with the same ingredient, the same dosage of the ingredient, and the pink box costs more. So I presume we all have the same bowels and it's not, affecting us differently since it's the same ingredient. So it is very, very pervasive into industries and products that shouldn't really logically have anything to do with gender. And just because it hasn't yet, affected the toothbrush market doesn't mean it might not one day. I could imagine Barbie toothbrushes and whatnot.
Okay, we got lots of questions. Representative Hammond?
Thank you, Mr. Chair. And thank you for taking our question. My wife wants me to buy her a 6-inch electric chainsaw, and she wants a pink one. And I told her, let's think about it because they're very dangerous tools. But the pink one is, I think, a few dollars more than the regular one. So this is a conversation going on. But you mentioned that certain products that are different colors might cost more. And would you believe that if it's a shorter run of production, that would cost more because the efficiency of scale isn't there? So, like for instance, if you price out a car and you want a special color from the dealership, they might charge you another $1,000 because they're not cranking those out regularly.
Sure.
Would you believe that the market sort of sometimes that's a market determination because of the smaller scale?
Because of the smaller scale, even if that color has nothing necessarily to do with gender marketing, this bill covers that. So it says if it costs you more to make, or it costs you more to buy, then it's fine. You can charge a different amount. It's only if it costs the same amount. It's only if the materials and the manufacturer and everything was the same and the gender marketing was different, that was the differential. That's what this goes after specifically. So that's all exempted.
No, I did see that loophole, that exemption. But having said that, it seemed like a potential loophole because now if the Attorney General's office calls up and say, we think you're overcharging, and now that merchant or the business and manufacturers now gotta, have to defend, lawyer up. And the lawyer says, well, how many runs did you make of this or that? You didn't use that as an excuse. So you really are just you're actually discriminating against pink. You're implying that pink is a feminine product, as though no men would want pink. You are actually, that's why, when I said Barbie, because that the whole point of marketing is to appeal to the consumer. And so if the consumer, a woman, prefers pink Dulux, because that means, it's okay for women, maybe. I don't know why they think that. You're saying, because they did that, that it, they should be lawyer up and they got to get tried. They got to change their pricing. They got to do all that, when it really is a marketing issue. Here's my problem.
There's a bunch of points in here.
I bought a backpack for my wife, and I was looking for the sale price. Well, the only one that was on sale was green, and they were out of them. And I said, well, what is your replacement? Well, you have black, but you got to pay more for that. So companies are actually marketing that price, the color change, whatever, is their choice. It's their marketing choice. And it really, my question to you is, you are basically discriminating against the color pink, because is there any other color? Is there any other shade that you think is?
The word pink is not in the bill, just to be very clear.
But you all agree, everyone agrees, that pink is what you're going to use for discrimination. Because if it wasn't pink, if there was one product that was black and the other one's green, and it says, and are you going to say did it say for women on the package?
If I may be allowed to respond to some of those multiple points. So maybe I'll try to work in order of the notes that I've taken here. So this idea that, there was a limited production of this thing, so now the AG's office is going after them. I think it's really clear. And it would be a very simple, 2-minute process for the AG's office to check whether or not a particular company has put out the same, Gillette, we'll say, has put out, so many millions of razors marketed for women versus razors marketed for men. If it's a limited production, then again, that's excluded in the bill. So that would be an easy, I guess we're not going to go after them. It's up to the AG's office whether they go after someone if they think even a claim of a limited production or an increased cost of any kind is, reasonable, that they don't feel like they want to go after and pursue that line of arguing. So the idea that I'm discriminating against pink in a bill that's saying you have to price things the same regardless of the color or how they're marketed. So not regardless of the color, because that was also a bit of a misconception. There's no color issue in this. We call it the pink tax, and I think that's where we're getting, because it is frequently the color pink or purple or what's considered feminine colors in a particular issue. But it's about, is it marketed to a particular gender? And let me be very, very specific, because you brought up, what if a guy prefers the color pink? Okay. In fact, there are makeup companies now that have as their models men wearing the makeup. So it's really not about sex. It's about, are you marketing to a particular gender? Is it feminine? Or is it masculine? And I don't mean is it a product that only women use? I mean, is it feminized or masculinized in the marketing, when every other factor means that it has the same cost of production? That is what it's getting to. And if in a bill that's saying you have to level that out, I don't understand the allegation that I am discriminating against something. I am trying to undiscriminate. It's being discriminatory now. Women pay $100,000 over their lifespan. Now I'm trying to level that playing field by taking gender out of the equation.
But here's where I disagree. There's nothing, discrimination is if they say we're going to charge you more because you're a woman. But
we are charging you more because we are marketing it to a gender.
The woman can buy the man version. The way I read this bill, that man version has to be exactly the same as the woman's version. The only thing different is the packaging. If that is true, there is nothing stopping a woman from buying that package, and they're not going to get charged more. And it goes. That is why I'm saying you're discriminating against the fact that the package might say for women rather than for men. What you're saying is that they need to advertise that it's the men's version or the cheaper version. They need to say on this for everybody.
No, they don't need to say for everybody. They have to not charge a different amount. It can still be marketed towards women. It just can't cost more. And by the way, didn't hear a question in any of that, but so I'm worried this has turned into a debate more than a hearing. But having said that, I don't understand. Going back to the previous thing, you're saying that women. I mean, I answered this question earlier. Women can buy, like I did with the scissors, the masculine product. But we live in a society that we say we expect, as all of the women here are wearing some feminine thing, our clothing. It may cost the same amount to make this shirt as your shirt, and yet I may have to pay more. That is the issue.
Okay. Representative Gibbs has already had a question. Anybody who not Representative Herbert has not had a question yet.
You said that 2 states have passed this bill. I'd like to know what the states are and get a sense if you have any feedback coming from those 2 states as to how the bill has been effective or not effective. I just would like to know what happened in those 2 states.
Thank you very much. At the risk of triggering some people, those 2 states are New York State and California, and all reports so far are positive. You can feel free to look up, just look up the words pink tax. There's a wealth of information online, and virtually no one thinks that this is an okay practice.
Okay, Representative Gibbs.
Thank you, Mr. Chairman. This is a follow-up on some of the questions asked by my colleagues, and I'm sorry that the gentleman on that side has left the room because that train of questions actually started with his. But this is essentially a would you believe that while indeed if the men's razor and the women's razor are the same, but one is marked for men and one is marked for women, regardless of the color, I can buy the men's if I want. But if I go to the cleaners with a woman's blazer, I have discovered that it costs more to get the woman's blazer clean than a man's jacket. And I do not have the choice to turn my woman's blazer into a man's jacket. I have to pay more for it. Would you believe that?
I would absolutely believe that, and I would further believe that women's haircuts, and you can't go into the salon and say that I'm not a woman unless you feel like trying to, change your gender identity for the day, cost more than men's haircuts for the same exact cut, even with short hair, even with, the simplicity of the cut. Many services geared for women are charged more for women than for men. When I get a manicure, for example, they market men's manicures. I never want polish. The only difference between the men's manicure and the women's manicure is the lack of polish in the men's manicure, but I still get charged for the women's manicure, even though I'm not getting polish and am effectively getting the men's manicure.
Representative Ammon has a question.
I just have one last question. Thank you for your good-natured testimony today.
Thank you.
Here's my question. You referenced the women on our committee today, and you also said that gender is a social construct. How do you know which of us is a woman on the committee?
I don't know your biological sex. I can tell from how people present themselves that they are presenting themselves in a feminine manner or a masculine manner, and that is gender. Your biological sex is none of my business. It should really be only your business, your sexual partner's business, and your doctor's business.
Further question. You see where this is going to go.
So when
This is where I was afraid of. Like, this is literally not about that, but okay, I guess we're going to
Just to
have to go
follow
there.
just a clarification, when you say woman, do you mean biological sex or do you mean
Gender.
so you
For the
mean
purposes of
social
this,
construct?
So, for the purposes of this bill, this is only the concept of feminine and masculine, not anything to do with biology. And in fact, as I already said, if it's something that you are biologically using because you're a woman, then that's not in this bill because there's no equal counterpart on the male side. So there's no such thing as the gender-based pricing, for example, on feminine products. I mean, by feminine products, I mean sanitation products, tampons and what have you, because there's no masculine version of that.
Representative Walsh.
Thank you, Mr. Chairman. This is, we'll have a question, but it's also, would you believe, being a biological woman and planning on staying that way, I've noticed all of my life, everything that is said here, thank you, that we always have to pay more. And I am in total agreement with this bill. Thank you for writing it. And that the fact that, yes, it's a free market, but not all women are going to go and hunt and search and peck for down other aisles to see if there's a less expensive, marketed to men's version of whatever it is they're looking for. I mean, when it's easy, when it's such as, I think this is deodorant or whatever this is.
Shampoo, I think, Dove. Yeah.
Shampoo. When they're right next to each other, yes, it's fun. It's easy to see the difference, but that's also easy to see that they're blatantly different and charging more for the one that is marketed towards women.
Gray bottle versus white bottle.
Right. So my question would be, if this were to be passed, what type of enforcement is there to this?
The-
Read the fiscal note.
So this is, she needs to
yeah.
put in a fiscal note?
No, no, no.
No,
The,
you don't know.
the-
You have the bill in front of you?
to be
Yeah,
fair, you don't
no.
have to read the fiscal note for
Right.
the
But-
enforcement is
but
in
there
the
was-
bill.
Back part, read
Right,
the
but there
fiscal note.
was,
The enforcement is in the bill. And this, but again, because the issue was brought up, can't a woman just go get the masculine version? What you are saying, therefore, not sex, but gender, that women, in order to merely just pay the same amount that men do in life, must undergo a process by which they change how they express their gender in the world. Because I have to buy masculine items. I have to buy if the woman's blouse and the skirt cost more than the man's shirt and the suit pants, then I have to buy those things instead of those things. Because that's the only way for me to, pay the same as a man, is to dress like a man and buy men's products. That all of my razors have to be black and all of my bottles have to be black and gray or what have you. So that's what you're saying, is that, well, if you want to save money, then be masculine, buy masculine products. That's been the argument consistently, is that, well, can't a woman go buy from the men's aisle or from the men's section and get the gray thing or the thing without the pink? Isn't that the case? And my point is, in a society where we do enforce gender, then you are saying that a woman has to present, and by buying products that are meant for men, present more in a masculine fashion.
Okay, so would you like to hear a story that's very similar to this legislation? Because I heard you only want a question from me, but Donna Susi actually brought a bill, and I talked to her about it. It was her very first term. She was a House member, and brought it to this committee, and the issue was dry cleaner, and the issue was, and she brought it, that the button-down shirt, she brought two, man and woman. And I didn't even know this at the time, but she said you can tell the difference is because the buttons go the other way.
Correct.
But I never knew that until that hearing. And the
Goes
bill
back to equestrianism, by the way, which
and the bill died, and the blurb on the committee was caveat emptor, which is, yes, the buyers, a woman needs to be aware that just because the packaging is aimed towards them, they don't have to buy that more expensive product simply to fit the stereotype of that pink means that they're supposed to buy pink, that they're not have to be Barbie. They could be Ken and buy the
you
black version.
just said what I said a second ago. You don't have to be Barbie. You can be Ken, meaning if I want to pay the same amount to live in this world as a man, have to buy masculinized products, which therefore means to some degree, as far as clothing and other things that are visible, my products, that I will have to present in a more masculine form to the rest of the world because I have been forced, in order to save the money, to buy more masculine items. And what I'm saying is, if you don't want to challenge the idea that we have gender, if you want to accept the fact that we have gender norms and that people are expected to present in a way that shows their gender, then at the least you can do is not penalize one gender when they go to actually buy the products to present themselves in that way.
And you get the final word. Thank you very much.
Well, thank you.
Okay. Thank you very much.
All right.
Brandon.
Red is on or red is off?
Red is hot.
Red is on. Red's good.
Good morning, Mr. Chairperson, members of the committee. My name is Brandon Garrod. I'm a Senior Assistant Attorney General, Chief of the Consumer Protection and Antitrust Bureau at the New Hampshire Attorney General's Office. I'm here today not to take a position one way or the other on this bill, but simply to point out some concerns that the Attorney General's Office have, not only in the fiscal impact, but also in our ability to enforce it. And, I'd just like to take the time to point out that, the Attorney General is here often testifying that a change in the law that puts new responsibilities into the lap of the AGs would necessitate additional resources. That does happen frequently, but it's not every time. We look very carefully at every bill, and we look at what we anticipate the bill would require us to do, how much work it has the potential to generate, and whether we could do that with the resources that we currently have. And if the answer is yes, you will not hear us over here saying, this is more work, therefore we need more resources. And a great example of that is the bill that's on following this bill, which would add a new requirement to the Consumer Protection Act. I will not be here testifying on that, saying that it would have a fiscal impact on the AG's office, because I don't think that it would. It's a very careful analysis that is done on every single bill to make sure that if we are entrusted with a new responsibility, that we are able to do it, both in the volume and able to do it meaningfully, so that a responsibility that has been entrusted into our office can be carried out meaningfully and we can enforce that law as it's written. So with that context, this specific bill, while, first of all, I just want to say that, as a general concept, being charged the same amount for the same product, regardless of your gender or your race or anything else, I would hope is something that everybody can agree on. Certainly something that, the Attorney General's office would strongly support. And in this bill, it has two different, tracks that we would be enforcing, one for goods and one for services. The comments that you're going to hear from me today are almost entirely geared towards the goods arm of this bill, because I think the requirements as to services are largely reasonable, enforceable, and could potentially, be handled, maybe with additional resources, but maybe even without. It's really the goods portion of this that, is problematic. So, and the reason I say that is if you look at services, the example was raised, haircuts and dry cleaning. If a salon is offering, a buzz cut, and a man wants a buzz cut and a woman wants a buzz cut, and they're charging two different prices, it is very easy for us to go in, investigate, look at, exactly what the product or the service that's being offered is and determine that they are substantially the same and say, no, you're charging the exact same thing for the exact same service for two different people because one is a man and one is a woman, and that violates this law. And we could take action to enforce that. That is doable, and that is enforceable, as anticipated by the statute. I would imagine probably the same with the dry cleaning example that was given. If two different, let's say a man's jacket and a woman's blouse, there's two different prices to dry clean them, to apply certain chemicals, wash them, or I don't know how, you see my ignorance on how dry cleaning works. But, if the service is exactly the same, and the price is different, we could do that investigation. We could make a determination of whether that service is substantially similar, for the man's service and the women's service. But I think it's very, very difficult, if not impossible, to do the same thing as it, pertains to goods. And I'll do my best to explain why. But it's the goods portion of this that, going back to resources and, a fiscal impact on DOJ, potentially what could happen if this bill was, signed into law as written, is that consumers across the state could file a complaint with the Attorney General's office for every single type of product, every single brand of product, every single type of product where there is a man's version and a woman's version, and say the price is different. I want the Attorney General's office to investigate. That has the potential for an enormous influx of complaints into the Attorney General's office, which we would not be capable of handling with the resources that we currently have. So that is why your fiscal note that you saw in my testimony here today is specifically here about the need for additional resources in order to enforce this bill. It's not just that it would be more work, it's that the specific work that would be required to handle what could be an enormous influx of complaints is beyond the capabilities of the resources that we currently have. And it's relatively impossible to anticipate the number of complaints and how many additional resources we would need to do it. Potentially a way to determine that would be to inquire with New York and California to see how it has played out there, but we simply don't know at this time. But in addition to the resources question, there are concerns that I have as it pertains to goods in terms of our ability to enforce this. Again, not the intention behind the bill, because I think the intention is good, but I don't want, and the Attorney General's office doesn't want, responsibilities that it can't deliver on. It doesn't want to create an expectation that, we are going to make sure that this law is upheld in the state, and then we don't have the ability to do it because of the way it's drafted. And I think that's what you have here on the goods portion. There is an inherent complexity in determining whether two goods are substantially similar. And there are 4 factors that are listed in this bill that we can use to determine whether, not 4, I'm sorry, there's actually 6 factors. The amount of time it took to manufacture such goods or provide such services. So again, for services, that's easy. We could figure that out. But for goods, I mean, if you use the 2 razor blade examples, the ability to figure out how much manufacturing time went into a specific razor is not something that is easily done. We have certain investigative techniques that we can use. We can issue subpoenas to company, so we can ask them to tell us how much time. But even if they respond and say it took this many hours for this one and this many hours for this one, it's very difficult, if not impossible, to verify that that's truthful, short of going to their plant where they manufacture these products and watching them do it and determining that one took longer to manufacture than the other one. And that same complexity and that same difficulty applies throughout these number of factors that we would be entrusted with evaluating every time a complaint about a good was filed in order to determine whether it was substantially similar or not. The difficulty in manufacturing such goods or offering such services, difficulty is not something that can be measurable in response to a subpoena. Difficulty speaks to difficulty. What amount of skill is required to do it? What type of machine is used? How complex is that machine? How many people does it take to run that machine? These are not the types of things that we have the ability to meaningfully and accurately investigate in order to perform that analysis of whether two goods truly are substantially similar or not. And I think that can be applied almost across the board in the various different areas where you have a men's version and a women's version of a product, such as shampoos and body washes, clothing. If 2 different sweatshirts, 2 different pairs of shoes. I think it's much bigger than if you. I guess what I'll say is if you truly have a scenario where the only difference in a product is the color, since we spent so much time on color, perhaps that example is easier and could be done. But that is not often the case. I mean, men's razors look different than women's razors. Sometimes they have more blades. One has more blades than the other. Sometimes they have different qualities of blades. I think, I just don't know. And none of us know because we don't have that expertise in the industry. So we would be entrusted with answering that question every single time that a consumer filed a complaint. And wouldn't be as simple as just, all right, somebody's going to file a complaint against Gillette, and then we're going to look at all of Gillette's products. Every single brand of razor could be potentially investigated, every single model of each razor, and that's just razors. I mean, it's, bicycles, calculators, backpacks, the materials that were provided give a number of different examples, and every single one of these companies, every single one of these models would be fodder for investigation by the Attorney General's office in order to determine whether or not the two products, if priced differently, are substantially similar or not, based on, you know, the factors that are included in the statute. And I'd just like to point out two other, you know, concerns, not necessarily related to the substantially similar, but in reference to the relief that the AG's office can bring, and some clarifying that I think would be helpful there if the committee decides to move forward with this. Currently, it anticipates that we can get restitution through a court if we find that, you know, two products are being sold that are substantially similar at different prices. It's unclear as to how we would go about determining the appropriate number of so if, I mean, one way that you could do it is it would require determining every single product of that type of product that was sold in this state, ordering the company to pay the difference between the two, and then administering some sort of restitution fund where the Attorney General's office is cutting checks to every single person in the state that bought one type of product and then sending checks across the board. I mean, that really also goes to, you know, the resources question and why we're here testifying about this today. And, you know, finally, Roman 3 under enforcement speaks to, we can impose a civil penalty not to exceed 250 for each violation, and then, you know, a subsequent penalty for a subsequent violation. But the bill as written does not provide any guidance as to how we determine what amounts to a violation in order to determine how we can find a business. You know, is a violation each product that is sold? Is a violation each type or model of a product that is put into the marketplace? Is a violation each day that this product is out there, or is a violation something else? You know, these are questions that we have to have the answer to in order to be able to go into a court and ask them for this type of relief. And if this does move forward, I would strongly encourage the committee to think very carefully about defining what amounts to a violation, so that the Attorney General's office would have some clarity in being able to enforce that provision of the statute if it became necessary. Happy to take any questions.
Okay, Representative Burrows.
Yes, thanks for taking my question. I was thinking about your example that might be easier with services, and I mean, I just thought of what you suggested, the buzz cut example. It could actually be very different if a woman has long hair. To do a buzz cut, I would think it might take more time than a male. Or if, like, I wanted to get my legs waxed and Representative Terry wanted to get his legs waxed, my guess is his might take more time than mine.
I beg your pardon?
All right, I'll use Chairman Hunt as the example. So, you know, I think that could be problematic too, just in terms of time, and it would have to be very carefully defined.
I think that you're right, but I think what this bill is seeking to guard against, and it does do a good job of this, is determining, you know, if in order to determine whether services are substantially similar, those are the exact type of factors that we could look at, and a business could say, yeah, here's the justification. You know, this person came in, but, you know, the problem with that is that there are women out there that just have a buzz cut and, you know, may want to maintain their buzz cut. And for that woman who wants to go and just have her buzz cut maintained the same way that a man does, it may not take any extra time. So I think that is the scenario that this is guarding against. And, you know, if this portion of the bill that deals with services were enacted, that's why I say, you know, under that exact scenario where the services truly are exactly the same, there's no additional time required, we probably could enforce that.
Representative Bilio.
Thank you. This is in regards to services as well. In a salon, you have many salons have menus, men's, women's. A woman can go in and point at the men's side and just say, I want a men's cut. And I'm not sure what the cosmetologist would do, but if that person wants a men's cut and it's listed men's and women's, they can point to, I want this men's cut. Or if you're going in for a manicure, again, I want a men's manicure. Even if it's a female, I think you can ask that.
I'm not sure.
I'm a cosmetologist, so you can.
Well,
you can.
Well, the question would be is if they have a listed price,
Right.
is that discriminatory if a woman says, okay, I want that product, that man's cut? Isn't that discriminatory if they say, no, you can't have it, or we're going to have to charge you more? Wouldn't that be discrimination, which is what the intent of this legislation?
I think that it certainly would violate this legislation if what you had is arbitrary pricing for the exact same services determined only by the gender of the person who's asking for the service.
Well, the reason I say that is because to me, I look at the Consumer Protection Act is to make the consumer whole. The restitution is, yes, it's true, we have triple damages, but at the end of the day, the idea is to get the merchant or to not discriminate, and so I'm looking at the discrimination aspect here, in that if someone is overcharging, okay, simply because of their sex, I guess it would go to the Human Rights Commission. Or you could take it, but our consumer protection statute doesn't have any language around that. The fact that you could not charge more simply because of your sex.
I'm not sure I agree with that. And I think that, that is a point that I overlooked, and it's a good one to make, which is that our Consumer Protection Act currently outlaws unfair or deceptive acts or practices. And there's
Right.
a substantial body of case law that defines what is a deceptive practice. And it's pretty well defined and pretty easy to spot. Saying something is something when it's something else. Saying something is endorsed by someone when it isn't. Basically lying to people in order to get them to buy something they would otherwise wouldn't buy. But the unfairness prong is very open to interpretation and basically looks to, is the practice unconscionable? Is the practice, would it raise the eyebrow of somebody in the world of commerce? And charging the exact same price for no other arbitrary reason other than, the perceived gender of the person requesting the service, could that be an unfair practice under the Consumer Protection Act? Absolutely.
Okay, so and that's
Under the
really
right
my question
circumstances.
is that if that is, then I think the issue that we all agree on is that no one should ever be charged more because of their sex.
Right.
But that if that they can get that service and at that same price. So you feel confident that the Consumer Protection Act would protect for that situation, or should we drop another line in there to clarify that?
I will not say that I feel confident because unfairness is defined. I mean, there's no clear way to define unfairness other than when you see something and you say, we think this practice is unfair. You investigate it, you determine the purpose behind the practice, the impact of the practice, and whether the practice is something that is so contrary to what's acceptable in our society that it shocks the conscience. And it's a case by case analysis that has to be done and is always dependent on the specific facts of the specific practice you're looking at. So I absolutely think, I will say I am confident that under the right circumstances, if you had a business that was charging different amounts for the exact same services with absolutely no other basis other than gender, race, age, anything else, some arbitrary thing like that had absolutely no bearing on the cost of providing the product or the service.
All the things
That I as the Consumer Protection Bureau chief would investigate that as an unfair practice, and
Perfect.
whether a court would ultimately agree or not, I can't say.
Okay. So
but-
we're going to take this up in subcommittee in the first week of February or so. So it'll give you some time to think that one through. But that in terms of you feel comfortable, because I think that's the loose end here, question here, that we would certainly hope the Consumer Protection Act would protect a consumer from a merchant saying, no, you can't have that price, you can't have that.
I mean, again, I don't know that I'm going to be able to, think it over and be able to provide a more clear answer because it all depends on the circumstances.
Okay.
But in that, the perfect storm of what is needed under this statute, which is identical service, identical product,
Right.
absolutely no difference other than we're charging a woman more for this than a man. I think that is an unfair practice. And I would, if
You
that
would pursue
complaint
that.
came into my office and my bureau and I looked at it, I would investigate.
Perfect. Representative Hammond, you have another question?
And I see we have some other hands here. Thank you for your testimony. You mentioned discrimination. You mentioned discrimination on the basis of age. Could that be applied to, say, a senior discount where someone over the age of 55 is charged 20% less than someone under the age of 55? Would the Consumer Protection clause apply to that scenario on age?
In the giving seniors a discount is an unfair practice.
Yes, that's what he
You,
says.
you mentioned discrimination on the basis of
No.
age, and that's that. I'm just asking if that applies.
Well, I think there's a difference between charging people more for something for no reason other than, I see where you're going.
Yeah.
I think that our society has commonly accepted that, senior citizens are entitled to discounts on things from time to time. And I do not think that is an unfair practice to apply those. And this is what I mean about, shocks the conscience. Under the Consumer Protection Act, you have an unfairness standard, and whether the practice shocks the conscience of society is one of the key factors that we look at to determine whether it amounts to unfairness as anticipated by that statute. I think that as a society, we routinely and regularly, give senior citizens discounts on various things with good reason. So I do not think that it would fit that definition.
Just one quick follow-up. Thank you, Mr. Chair. How do you determine what shocks the conscience of society? How do you make that determination? Just curious, because this is a bigger discussion, I think. Thank you.
It's case by case. You look at the practice, you look at if the practice is an outlier in the industry, it's completely contrary to what everyone else is doing, what, people deem acceptable. This is the standard that has been adopted that, it
Right.
says that
Get
whether
behind
the
that.
act or practice, is sufficient, has a sufficient level of rascality that it would raise the eyebrow of those that are familiar with the world of commerce. So if people that are familiar with the world of commerce look at a practice and say, whoa, that's way out of line, there's no reason for that, that's bad, that's predatory, but it's a squishy analysis. There's no one factor that you can look at and say, if this then shocks the conscience. It's a case by case basis. And that's why I say, I can't say I'm comfortable that, the Consumer Protection Act would cover this, because it would depend on the very specific facts of the practice, how long it had been going on for, what the basis was, what the impact was, the exact specifics of what was going on. All those things are relevant to doing a much bigger legal analysis of whether or not it potentially violates our statute.
Okay, so I see 7 hands, and we're already again getting behind ourselves. So, would you be willing to stay around so these reps who have more questions, you would be able to take them out in the hallway for us? Is that
Like right now?
yeah, like right now? Otherwise, you could call him.
I think he should go back, call somebody in California and New York, and they have all the answers. And then the next time he comes here, he would have the answers right at his fingertips.
Okay.
Talk into the microphone, please.
So the question is being posed is that given that we'll be having a subcommittee in early February, is he willing to call people in California and New York and see how they address these issues? But I don't. To me, it's pointless because every state's consumer protection statute is separate. It's different. And ours is unique, and this is the man who's in charge of enforcing our consumer protection statute. So I have full confidence that if ever someone had a complaint or has a problem and they call him up and he will respond, that, and because he's actually got a whole you got volunteer, you still have the volunteers that help out and help people, and that they can address these issues.
I'd be more than happy to provide my contact information. If folks have questions, they can follow up with me. I don't think it would be meaningful to simply call New York and say, hey, how's it going? New York is a very different state than New Hampshire. Their attorney general's office is significantly larger than ours is, and it is just not a fair comparison. However, I think one inquiry that could potentially be helpful, if the resources were allocated to us to enforce this, would be to see whether any enforcement actions have been brought under the goods prong of this in either New York or California, assuming that this legislation is identical, and whether there were any issues.
Okay. All right. Is that okay? Help for those who want to keep asking more questions, and we're already behind.
Well, I actually had a comment as the ex-director of the Human Rights Commission that I thought might be helpful.
I think you can do that in the subcommittee.
I will.
The
Thank you.
subcommittee would be great to hear.
I
how
will
you
do
feel.
that.
Okay.
Mr. Chairperson, could you provide my contact information to the committee. If anybody has follow-up questions, call or
The
email,
best thing to
I'd be
do
happy
is that if you email and just say email House Commerce with your information, and that will go to everybody in the committee room.
What's the specific address?
House Commerce.
At.
Uh,
I'll figure it out.
I'm sorry. I appreciate you doing this for me.
Sure.
Thank you.
No problem.
Okay.
Thanks.
All right. So I will close the public hearing on 1406. I didn't read the blue sheet. I gotta get. No, usually no. Yeah, it's somebody over there. Right. And since there's nothing on it, how about 1071? Might as well bring it over while we're at it. Okay. All right, we're gonna now open up the public hearing on House Bill 1071, the right to repair certain educational technology. And do I have the pink cards? Did you fill out a pink card? No, you can do it later. Do it later.
So I also have an amendment to pass around.
Yeah, so we've had right to repair type legislation in the past, and this is somewhat similar. So, okay, go ahead.
So, hi, I'm Eric Gallagher, representative for our Merrimack County District 20, which is Concord Ward 6, and I'm here to introduce HB 1071 relative to the right to repair certain educational technology. So, yeah, you're right that I did actually have a previous right to repair bill earlier this term. The main difference there between them is just what specific type of product it's focusing on. The previous one was more focused on home appliances, so stuff like blenders or mixers or irons, clothes irons or stuff like that. And then this one's more focused on educational technology. So the specific motivating case for this one is for cases where school districts have bought a large number of Chromebooks and then been unable to repair them because Google won't refuses to repair them anymore, and also refuses to let anyone else repair them either, since apparently doing so would require information that they're not willing to give out. So actually, since having filed this bill, the court case where Google and school districts were fighting this out in court actually got settled, and Google agreed to allow these Chromebooks to be repairable. But I still think having the law on the books is good anyways, just in case they later change their minds, or in case there's a problem with some other educational technology provider refusing to repair stuff. So yeah, this will save school districts money, since if they can repair their products, they don't have to be buying new ones as much and spending taxpayers' dollars on that. And so to address the amendment a bit, there was one little drafting issue where with the definition of necessary software updates. If you look at how it's currently written, it's a run-on sentence with commas. So the existing text, necessary software updates means security updates to patch exploits that, if left unaddressed, leave the user vulnerable to cybercrime, bug fixes, patches, corrections. It sounds like those last three, bug fixes, patches, and corrections, are the things that the user's being left vulnerable to, but it's not actually modifying that. It goes with the security updates from previously, so the amendment just kind of clarifies that wording there by splitting it into a separate sentence. And also just some updates on the state of other right to repair legislation around the country. So California has passed some of their right to repair legislation. And I think that's kind of an instructive case to look at, because I remember getting questions here at the previous hearing. Oh, well, won't this be burdensome on the companies that have to comply with it? And that was the argument that Apple was making at first against California's law. But then after looking at it some more, they realized, oh, actually, we can comply with this and it'll be fine. And then they ended up supporting it in the end. So yeah, I think that would be the same case here. And so Minnesota's also passed right to repair, and the FTC has also been taking steps towards doing federal administrative rulemaking about right to repair. But having talked with some people in contact with them, they do say that it would be also good to do this at the state level as well. Just, to kind of show that there's momentum behind it and that people actually want this. So, yeah, that's HB 1071. I'll take questions now.
Great. Any questions from committee members? Representative Gibbs.
Thank you. Representative Gallagher, in the original bill and in the amendment, I'm looking at the amendment, this is line 3, it refers to security updates used to patch exploits. And I'm not sure that exploits is really the word that should be there. Maybe errors. I'm not sure what.
No, exploits is the correct word. That's the term of art in the computer security world for vulnerabilities that an attacker could potentially take advantage of.
It is a term of art.
Yeah.
I'll take your word for it. Thank you.
Yep.
Okay. Any other questions from the committee members? Seeing none, thank you very much.
All right. Thanks.
I have one other card here. Chris Gilrin from TechNet. And Representative Geller, you will fill out a card, right? Yeah. Okay. Great. Go ahead. Thank you. Oh yeah, you got to.
That's
you go.
better. My name is Chris Gilrain. I represent TechNet in the Northeast. TechNet is a trade association comprised of over 100 companies in the innovation economy. Here in opposition to H 1071. TechNet's member companies that do manufacture technology like this strive to offer a broad network of trained, authorized repair outlets for technology like this to be repaired. These are complex systems that also tend to house a significant amount of personal data. So in this case, it would be student, teacher, school district data on these devices. Using authorized repair channels has accountability both for the safety of the repair, particularly when we're talking about things like lithium-ion batteries, as well as the security of the data that is housed on those devices. For those reasons, we oppose H 1071 as it does not include necessary protections for that data or necessary training for the people who would be doing these repairs. Appreciate your time and happy to take any questions. Our written testimony, I believe, was submitted. We are a signatory onto a group letter
Yeah,
from
we
the
did
Repair
get it.
Done Right Coalition.
Okay. Any questions from the committee members? Seeing none, we thank you very much for coming up here and
Thank you very much.
letting us know. Is there anyone else who would like to testify on House Bill 1071? Only once? Only twice? Close the public hearing on 1071. I had a sneaking suspicion. Okay, we'll open up the public hearing on House Bill 1624 and hear from Representative Wallace. Good morning, Representative Wallace.
Good morning, Chairman Hunt and members of the committee. Thank you for allowing me to introduce House Bill 1624. For the record, my name is Scott Wallace, Rockingham County, District 8, the town of Danville. Once again, I'm introducing my bill that would remove the prohibition in New Hampshire on the home distillation of spirits. As you're all probably aware, we just became legally able to make our own wine and beer here in the state in 2012 or 13, even though the Craft Brewing Act was signed into law by President Carter in 1978. As we all know, the Liquor Commission has a kung fu grip on all things liquor, and as such, without that permission slip from the Liquor Commission, you can't do anything related to that. That being said, we did get successfully the ability to brew wine and beer about a decade ago, and this is just a natural evolution of the hobby, if you will. My bill would allow those of us that brew wine and beer at home in the particular quantities that we're allowed to, 100 gallons maximum per household with a single individual in said household, or up to 200 gallons of wine or beer with 2 or more individuals in that household. Only that amount of wine or beer, also known as wash or mash in the trade, could be used to produce alcohol, which would give you roughly a 10% yield. So maybe somewhere between 10 to 20 gallons as a function of your household size and how ambitious you might be in the pursuit of this. The bill has been amended a couple of times over the years, and as introduced, this is how the bill was amended most recently. Currently, there are 9 states that allow home distillation of spirits. Some of our neighbors, including Maine, Massachusetts, and Rhode Island, most nearby. Others are spread throughout the country, Alaska, Arizona, in Iowa, and Indiana. I believe in Missouri was the first. Historically, we've had an issue getting it out of committee on the basis that this is not lawful federally. Well, that doesn't seem to matter in these 9 other states. They've moved this forward, and New Hampshire does have a tradition of doing things on our own, despite what the federal regulators or our federal overlords might say. If we consider, we've got medical marijuana program here in the state already. This very committee has several bills that they're considering moving forward that would legalize cannabis recreationally, despite the federal prohibition on that activity. And also firearms. We're a 2A sanctuary state as of last biennium, so we won't, under the color of law, help to enforce any federal firearms laws promulgated after January 20th, 2021 at this point in time. So I think that argument that we should move this forward based on it being unlawful federally that's probably in the rearview mirror at this point. Interestingly, there was a lawsuit filed in the end of December of last year out of Tampa District Court, or Tampa Federal Court, excuse me. I haven't read the pleadings yet. It's very new, but this lawsuit argues that the prohibition on hobby distillation at the federal level is unconstitutional based on the repeal of Volstead Act, which was prohibition, as you know. So it'll be very interesting to see how that lawsuit moves forward and what the outcome of it is. Additionally, going back 8 years ago when I first introduced this bill, we've had a little bit of movement at the Liquor Commission. Initially, they weren't all on board, and I think they've moved to kind of a neutral position at this point. I expect they'll be testifying behind me to their actual position, so don't take my word for it. So that's where we're at this point in time. This is an up-and-coming activity for the home distillers, and we're making progress throughout the country, and I'm asking that you would support us in this endeavor. I'd be happy to take any questions.
Okay, so I have the most straightforward question.
Yes, sir.
Have you ever applied for a federal license?
No.
Do you know, therefore you have no idea what a federal license would cost?
We've looked into it. It's in order to do this, even the smallest federal license is about a $1,600.
That's not what I heard. So why don't you do a little investigative work and find out what exactly the federal government is requiring, so that maybe we could pass a law that says that if you've got your federal license, you can absolutely home distill.
You're missing the point, Chairman Hunt. The point of the bill is to remove the state prohibition. The federal government has already granted us authority to make the alcohol. Alcohol, as you know, is produced during the fermentation process, which is already lawful in all 50 states and territories. So the act of distilling is merely concentrating the already lawful production of alcohol that occurs at the fermentation process.
We have a chicken or egg problem here. Clearly, the federal government has a law. Whether they enforce it or not, it's not, we're, the end of the day, they expect us to enforce their laws. And all I'm saying to you is, what I want to know is what it would cost for you as an individual to get a license.
It doesn't cost anything to get a license to make beer or wine because it doesn't exist. And that is the point at which alcohol, which is the key ingredient, is created. And the creation is the issue.
Fair enough. Okay.
Additionally, I'd turn that around and say, what are you even taking up cannabis for in this committee? It's not legal federally. So what are we doing?
We absolutely, the commission, as a member of that commission, what it was made clear to us is that at this point, and it could change, the Attorney General's office, the federal Attorney General's office, does not allocate any money for enforcement of marijuana statute. And so therefore, that is the reason why states are able to go ahead and do it. But at any moment, a drop of a hat, the Attorney General might decide that they do want to prosecute. And then there would be a problem across the country.
It sure would.
But what I've heard lately is that President Biden has, there is already a proposal to move it from Schedule 1 to Schedule 3.
Correct. And there's been an unwritten, shall we say, non-enforcement of the home distillers. Moonshiners, that's a completely different subject matter and a completely different scale. And that's for the purpose of revenue production.
But
this is not
if you
what we're
want to
talking about
use
here.
that analogy about the marijuana, I have no idea whether the Attorney General has any money or the DEA has any money to go enforce the home distilling statute. Theoretically, if they're not, there's nothing stopping anybody to home distill. I can assure you our Liquor Commission is not out there looking for anybody. They're not trying to enforce anything unless somebody drops a dime on them. So if you want to use the marijuana analogy, I say you should go ahead and just keep home distilling because nobody's going to enforce it.
But the fact remains that they could. So that's why we're here to do this the right way. and
Well, I
do
was to
this
say,
properly.
all those states have passed it, have all said with the caveat that just by the way, it's not legal.
Correct.
Okay. Oh, we have a Representative McVeigh. How are you, sir?
Good, good. A lot of shoveling this morning.
Okay.
A question.
Yes.
I'm a little confused here, but I think you might have inadvertently answered my question. You're only talking about distilling from wine and beer. Is that because you don't need a license to do that? So this doesn't include grains and corn and anything like that?
No, actually, wine, beer, mash, and wash, they're all synonymous.
They're all the same?
Yes, I mean, beer is often made from grains, and not just barley and hops, or rice. Wine is typically made from grapes, but sometimes fruit. So anything that you can ferment can be distilled. So you could use sorghum, you could use, strawberries, bananas, coconut, anything with a sugar in it or a starch can be fermented and produce an
Just a
alcohol.
quick follow-up.
Further question?
You could make bourbon, you could make gin, you could make vodka, you could make all those things?
Correct.
Okay, thank you very much.
Sorry, McAleer. Sorry. Sorry. Okay. Haven't seen you so long, I gave the wrong name to you. Okay. All right. Okay, here we go. Representative Post.
Would you believe that, I believe it was in 2022, I passed a bill in this committee for hobby liquors?
We did file it last year. This is fourth or fifth time around at this point. You may have voted for it, but it
It
was.
did pass.
No, we have not passed it because we didn't want to send the false impression to anyone that it was actually legal to do it. So if you go pass it, if we stay to pass it and the governor signs it, everybody says, "Oh, well, we can go out and do it." And then when the feds show up or something gets enforced or someone drops a dime, and all of a sudden you've got, the ATF, not the DEA, the ATF visiting you, you might want to blame the New Hampshire legislature for passing it. Any other? Okay, so you're all set? Okay. Representative Ammon.
Thank you, Representative, for taking our questions.
Of course.
And full disclosure, I'm a co-sponsor on this, so.
Are you allowed to ask questions?
I think I can ask questions.
Okay.
Or testify. I can't do
Okay.
both, right?
Correct. That's fine.
Just not both.
You gave the example of us being a Second Amendment sanctuary state. Could we do something similar with liquor enforcement that, the state resources wouldn't be used to enforce federal home distilling enforcement?
It sounds like a potential amendment, Representative Ammon.
That's what he's saying, yes.
I don't see why we couldn't.
Okay. Okay. Anything, basically, if I understand it correctly, is we would pass a statute that would say that the Liquor Commission would not enforce the statute.
Which would be a similar position to the state of Iowa. They don't
Oh,
specifically.
that's what they did.
They've taken the position that they haven't said it's okay, but they've also they're not going to
Enforce
say
it.
that it's unlawful.
Okay.
They're neutral on it. Do what you want.
All right. Thank you very much. I have one other card here, Representative Cantons from Compton. I'm sorry.
Good morning, Mr. Chair, and thank you, members of the committee. I'm here to support. I'm also a co-sponsor on this bill, and I'm coming at it from a kind of a different angle. We've been toying around with the idea of buying a still for experimentation purposes because I have a farm and I grow specialty berries. But stills are kind of expensive, in the scheme of things, especially if you're not sure about the legality of it. And I've heard here said that it won't be enforced, but if you're going to drop, $1,000 to $5,000 on a still, you want to make sure that that's not money thrown out the window. We're growing a specialty crop that is used for gin around the world. And we would like the chance to experiment with recipes. However, because we don't have hobby distillation being legal, I am not willing to risk my farm for that. And I think it's really important that as a farmer that we have different outlets for value-added products. And this would be a value-added product for farms. And to experiment with recipes before spending the money for licensing to see if this is viable, etc., I think is extremely important. And the other thing is that there are a lot of universities online and in person that are available to people to learn about distillery and distilling. And as my former colleague said, this is important. Massachusetts and Maine have both passed laws similar to this, where it is legal to distill alcohol in those two states. And to say that we can't pass this law because it's not legal federally, we do this all the time in New Hampshire. So I would urge this committee to seriously consider passing this law, because there's some of us that want to do it the right way. And we don't want to go through the licensing, and we don't want to spend the money for a still unless we can do it because it is state law. And I'm open for questions.
I don't understand. You're getting a distillery, or you can't sell it.
I don't want to sell it, but we want to experiment with recipes on our own before we decide if this is an avenue we'd like to really delve into.
And then sell it.
And then we would have to apply for the licenses and everything else federally. But if we can't, but we have to have a still first.
And evidently, you can buy one from Amazon.
Well, you can get them. There is a still company in New Hampshire, yes, but to make it legal, I can't make it legally.
Got it. Okay. Any questions from the committee members? Thank you very much.
Thank you.
Chief, are you willing to come over here? I have a couple of questions to ask you. And we have a deputy.
Yes.
Who is
Thank you,
has a
Mr.
legal background, so so he brought his counsel.
Thank you, Chairman. For the record, my name's Mark Armaganian. I'm the Chief of Enforcement for the Liquor Commission. With me here today is Danielle Elston, our Deputy Chief. As we were with the original version of this bill, we are neutral on it, but we're here to take any questions that you may have.
So what exactly does our statute say? Do we actually statutorily say no distilling, or we just never allowed it? We didn't put it into what is allowable.
Correct. There is no, I don't believe the language specifically says no distilling.
It does say
It says if you're going to, the statute only allows for beer and wine. And then if you're going to sell or make it, you would need the license to do so, but we don't have a license that allows it.
So is it possible that, I guess you can't answer this question. You obviously have to take it back to the chairman, but that if we were to pass a statute that says that we don't want you to enforce that regulation.
I would hope that there's a better way to get there, Mr. Chairman, because
Okay.
I would not want to have to change our position on our enforcement ability. So if there was another avenue to get there, I would definitely be open to those.
Oh, good. So you'll go back to the chairman and find another way?
I'd like to talk to the representative who brought up the issue of an amendment, just to see what the ideas are behind it.
Right. It was just, I guess, I don't know. Do we do this, the Second Amendment? You say that we have some?
Oh, yeah, so.
Yeah,
I think it was House Bill 1178.
Last year or this year?
It was 2 years ago, yeah, and that it specifically said that the state will not use our resources to assist the federal government in enforcing Second Amendment laws passed after 2021.
So, why don't you look at that for us?
Do you know what statute that specifically fell under?
I could look it up, but
All right, we'll get back to you on that. All right. Anybody have any questions for, yes, Representative Spear? You got to have your mic, yeah.
That Bill 1178 says that we won't help the feds and
Right, we will not
that
facilitate.
doesn't mean the feds can't come in and do something.
That is true.
So I don't know how that's going to help in this case.
Well, it's
Except
like I
that the
say, what
feds
we
don't wanna
learned
do
with
anything.
in the marijuana commission is that it's basically it's allocation of resources.
Yeah, no, I understand.
So if the ATF says no, we're not going to go out and chase down people,
Right.
unless I think what I would think is that they'll chase you down if they think you're selling it. If you're trying to
that
sell,
good
which is
enough for this bill?
moonshining. That's it. But yeah, okay. We have go ahead.
so it's RSA 159-E.
Well, that's what we like to do here in commerce: is find solutions that we can all live with. Okay. And February 1st, early February.
Awesome.
Okay.
Thank you.
All right. Any other questions from the committee members? Seeing none? And fill out a card for me, please. Thank you. Okay. With that, does anybody else would like to testify? No one else? Seeing none, we will close the hearing. And we got back there. Okay. What are we doing? We're doing relative to liquor stores, 1198.
Thank you very much. So today I'm dealing with a somewhat simpler topic, and I'm actually in favor of
I
the
don't
bill.
think I've ever seen you so often in our
I
committee
know
room.
it's like probably more than I needed to do, but I've had a good time anyway. So it's always fun over here. At least if you're a visitor. Though
And you did do a card, right?
I did. I haven't passed it around yet.
Okay. Not that we don't know who you are. All right.
Of course, now you've Reverend Grassi, so we a very good looking guy. I think we look a little alike. So like,
Yeah,
with
oh,
white
yeah.
hair and the square head. But anyway.
All right. I don't know. He has a better haircut than you did.
Oh, he does. Yes. Okay. So, anyways. Yes. So I'm still representing Timothy Horgan. I continue to represent Stratford County District 10, which is just the town of Durham. And actually, we don't have a state liquor store. You have to go to Lee or Dover to partake of their products. But we still like the State Liquor Commission in Durham too. So and this is a repeat of an early bill from 2022. And actually, Mr. Chairman, you and the committee were very helpful to me because the thing I came up with was much more complicated and had some, and you boiled it down to like the most interesting part of it. So it's pretty simple, and it actually came very close. It sailed through the House without much trouble, and then it went halfway through the Senate, but they sent it around to Finance, who then didn't see the wisdom of it, but maybe they'll hopefully they'll feel differently about it this time. So.
So this is just the way we send it.
Exactly. Yes.
Well, then it's dead on the Senate. Why would we do that again?
Ironically, it was the Finance Committee, and actually, the financial part of it was actually like unimpeachable. It was more on the principle of it. And what the principle of it is that, well, right now the liquor stores keep stores on main routes where traffic is heavy open on Sunday or any legal holiday, but there's 3 exceptions, which is Easter, Thanksgiving, and Christmas. And so Thanksgiving, Christmas are defined in existing law. Easter is actually not a legal holiday, and there isn't really any simple way to define it in the law books. It moves around from year to year, and actually different religious groups observe it on different Sundays because it has to do with it's the first Sunday after the spring equinox, but there's various opinions about how to calculate that. So that's why it moves around a lot. There's also the Jewish feast of Passover, which is basically the same holiday, and that's actually fixed on a exact date in the Hebrew calendar. But then the Hebrew calendar keeps up with the fact that like there are 365.25 days in a year rather than 360 by every so often adding a whole extra month. But I've already gone off into the. Probably should have just read my testimony out loud. So it's a simple piece of enabling legislation. Doesn't require these stores to be open on those 3 days. It just gives the commission the option of ordering it. They're free to keep them closed instead. And full-time employees will be guaranteed at least 1.5 times their regular pay, and all other work rules will still apply. And it's a union shop with a very strong union, but has a good relation with the Liquor Commission. So I'm sure that part of it will be. That part of it will be worked out. And the purpose is simply to better serve the public by giving them more opportunity to buy wine and spirits on those 3 days and to enjoy them responsibly. I was mostly thinking of travelers who need to pick up a few bottles for responsible enjoyment at their holiday get-togethers, though it may also be useful for restaurants and caterers who are open on one of those 3 holidays. And I think the fiscal note, as it did last time, demonstrates the Liquor Commission will, I'd say, almost certainly make more money if HB 1198 passes. So the sales on Easter Sunday, it's fair to assume they'll probably be similar to any other Sunday in March or April, and those apparently average about $1 million in gross sales. And then the labor costs, which is the main cost of opening the store on the day when it's closed, would amount to about $53,000. So it looks like they would make about $947,000 if they're open on Easter Sunday. I mean, it may cannibalize some sales from earlier in the season, but probably it'll be about the same. Thanksgiving, Christmas, a little bit harder to predict it. That is their busy season. The fiscal note describes the sales as robust, and if you've ever visited one of our excellent stores, of which we're all a all like all of us are citizens of New Hampshire are essentially shareholders in us. Those stores are indeed very busy right before Thanksgiving and Christmas. I enjoy going there right before Thanksgiving and Christmas and getting some bottles of New Hampshire-made wine to bring down to relatives in Massachusetts. But the break-even point for the opening of those 2 days is about 5.3% of the regular sales. I'm sure the sales will be more than 5.3% of what they would be on a regular day. And as I said, once again, it's just enabling legislation. So no stores they're closed now. They can only have to open. It's just a business decision they can make if they feel it's worthwhile opening the store on those days, which from a business standpoint, I believe it would be. So that basically is my bill. I made it. It's probably even simpler than I made it sound. And believe me, you don't want to try to define Easter in law. I did that 2 years ago, and it was just a nightmare. And unfortunately, if we pass this bill, there's only one reference to Easter left in all of the RSAs, and that's to a celebration called Gold Star Mother's Day, which is the Sunday after Easter. And the governor will still be able to sign a proclamation celebrating that, regardless of whether we pass this, because what it actually does, we're just crossing out one sentence from the RSA about when the liquor stores can be open. So I'd be happy to take any questions.
Representative Bullion.
Yeah.
Yeah. Thank you for taking my question.
Yeah.
Why are you bringing this bill forward? How would it affect the state, residents, yourself? I just don't get it.
Well, the original version of my bill had a couple of other issues in it, but those were not worth pursuing this time. So it's just, I just feel it's worthwhile to have some of these outlets open. I mean, even aside from buying their excellent products they're also they also always have clean restrooms. They also now have vehicle charging stations, which in the back of many, which I guess is more an initiative of the landlords. So I just think it's worthwhile having them open, especially we have two, and I guess they're planning to build more that are at rest areas too, and the rest areas are open anyway, so we may as well have, this part of the rest area open too for those people who, for whatever reason, good or bad, find themselves traveling on the holiday. I know I quite frequently find myself driving down there especially on Thanksgiving Day to visit relatives on the other side of the state line, but thanks.
Okay, any other questions from the committee members?
Yeah.
Thank you very
I'll
much.
just say, Mr. Chair, this version of the bill is much better than my original one from 2 years ago, but that's, thank you.
That's because we did it.
Thanks. That was my point. Thanks.
But it still died in the Senate. My advice to you is that when a bill dies in the first year of a 2-year session, don't bother bringing it back in the second year. Just, you got to wait till some people changed in that other body, and then bring it back.
Well, this was
But
the
if you
second year.
keep coming back every year, then
Well, this was in the second year of the previous biennium, and now it's the second year of this one. So I let it
but it's
rest
the
for a
same
year.
people on the Senate side.
Well,
It's the same. Let me put it this way: it's the same chairman of the Commerce Committee who didn't like it the last time.
Yes.
And I don't think he's going to change his opinion this time.
although one senator,
No, chairman of the Senate side.
Yeah.
Chair of Senate Commerce.
on the other
No,
hand,
I'm the one who wrote the amendment. What are you talking about?
yes,
man?
and also on the other hand, the one Republican who stuck with the bill the second time around is now the president of the Senate. So you never know. But thanks.
Okay. Yeah. Anybody else wants to testify on this issue? See none. We will.
John, question?
Oh,
Why do you not like it?
what's that?
Why do you not like it?
I didn't say I didn't like it. Because I wrote this amendment. I wrote this. I'm the one who. I said the Senate chairman
I'm
of
sorry,
Commerce.
I didn't hear that. Thank you.
Senate chairman. Yeah. Was the one who doesn't like it. So. Okay.
Part of the war on Christmas.
Oh yeah. I was scheduling on time. Okay, we'll open up the public hearing on House Bill 1621 and hear from the prime sponsor, David Brees. All right. Good afternoon.
Good afternoon, Mr. Chairman. Thank you. I'm not the prime sponsor, but I'm one of the sponsors, and
Okay.
I'm very happy to be here. I'm David Priest, representative of, of District 17 in Hillsborough County in Manchester. And I'm here to speak in support of HB 1621 to distribute posters and brochures and other information to liquor stores about alcohol use disorder. To start off with, excessive alcohol consumption is the third leading preventable cause of death in the United States. On the average, 79,000 people die, and 2.3 million years of potential life years are lost each year. Excessive alcohol consumption is also associated with multiple health and social consequences, increased health care, criminal justice costs, and lost worker productivity in the form of missed work, diminished output, and reduced earning potential. Now let's take this to New Hampshire. The 2012 report by POCON Research documented that excessive alcohol consumption costs New Hampshire more than $1.15 billion annually in lost productivity and earnings, increased expenditures for health care, and public safety costs. This $1.15 billion represents 2% of the state's total personal income. Not included in this total is an additional $218.6 million in discounted lifetime earnings lost each year by almost 300 individuals who die prematurely each year in New Hampshire as the result of excessive alcoholic consumption. The state and local government share of this $1.15 billion in costs of excessive alcohol consumption is estimated to be $251 million a year. In a recent 2022 report by the Robert Wood Johnson Foundation and the University of Wisconsin, New Hampshire has the highest alcohol consumption per capita of 4.76 gallons. New Hampshire consumption rate is almost double the goal set for the United States. Over 21% of the New Hampshire adults drink excessively, and 33.1% of the driving deaths in New Hampshire involves alcohol. My fellow representatives, New Hampshire has a problem. We have a serious problem. HB 1621 is one way to address this by reaching out to the public and educating them on alcoholic abuse, as well as what resources exist in their community that can help them. I thank you for this opportunity to speak. I will answer your questions, and I do have a written statement to be distributed to you. Thank you.
Okay, you ready for questions or? No. You take questions?
Yes, I will.
Okay, Representative McGill.
Thank you, Mr. Chairman. I'll start. I didn't catch the source of the data where you said 21% of all New Hampshire adults drink excessively. So I'd love to know
That
that.
was with the Robert Wood Johnson Foundation and the University of Wisconsin. It was a special report that was prepared.
Thanks. So my
Further question, may I
follow-up-
inquire?
Thank you. There's a lot of places you can get alcohol, like in a restaurant or a bar.
I understand. Yeah.
So I don't actually know, I bet someone here does know the breakdown of, what percentage of alcohol is purchased in state stores versus licensees. So why just do this in the liquor stores, especially when many of those customers are repeat customers? They're going to get the same brochure, once a month or twice a week or whatever they do and throw it away.
Well, however they decide to distribute the brochure is one thing. And I think the intent of this was to try to start with the state liquor stores. And if that was effective, we can move on. But I think that was the intent, was just to start with what we could control.
Can I ask one
Further
more
question?
Thank you. So you said if that's effective, we'd move on. How will
And I
we,
don't know that
how will
for
we
sure.
know
I don't know that for sure.
it's effective?
Yeah, I don't know
Okay.
how, if we would move on, if this was the intent, but I think this is a good start to accomplish what we're trying to aim, and that is to educate the public that alcohol is a disease, it's toxic to one's body, and it could cause your early death.
Representative Patusek.
Thank you, Mr. Chairman. I noticed on the handout, in 2022, the Robert Wood Johnson Foundation found that New Hampshire had the highest consumption per capita of 4.6 gallons. Is this based on products sold?
Yes.
Okay, realizing that probably half of the alcohol sold in the state of New Hampshire is to residents outside of the state of New Hampshire.
It could be. I don't know. I don't know how they came up with this number, but it is alarmingly high when you consider the other states.
Follow-up?
Further question, may I inquire?
Thank you, Mr. Chair. I know for a fact that two of the state stores on Interstate 93 typically have no less than a half a dozen vehicles, panel trucks, vans, with out-of-state license plates, and they are loading them up with trolleys of liquor to go out of state and be sold at some other place.
Oh, I would believe that. I see that all the time as I'm driving to and forth from Concord, and I see the license plates. I understand that. And if we can educate the out-of-staters, that's great too. But we've got to start with the people of New Hampshire and see if we can bring this rate down and the number of deaths.
Representative Gibbs.
Thank you. And thank you for your testimony. Considering the fiscal note on this bill, shouldn't this bill have an appropriation attached?
Yes. And it will probably go to the fiscal committee afterwards.
I'm sorry, I didn't hear that.
It will probably go to the finance committee for a fiscal note and to determine what amount of money would be spent to do.
Thank you.
this.
I don't have my copy. It should say on the fiscal note.
Yes, it says on the fiscal note how much is needed.
Yes. Right.
Sorry, so that the finance committee would deal with attaching the appropriation?
Correct.
Thank you.
Okay. Well, actually, Representative Walls just hasn't asked a question yet.
Just another point, following up with Representative Patuchek. I live alone, and when I go to the state liquor store, I might buy a few bottles of wine. That doesn't mean I'm going to consume those bottles of wine. It could take me a year to consume those. Or I might be buying them as gifts for others. So I think, to his point and mine, that's not considered as part of this. It makes, this kind of makes New Hampshire sound like we really have a huge problem when I don't think it's that.
We do have a big problem.
I don't know if it's that big a problem,
We
but
do have a problem.
okay, all right. Thank you.
Representative McGee was first.
Thank you, Mr. Chairman. I just want to go down the road of things that are harmful and are likely to cause your death sooner than your natural death, like alcohol. There's also smoking. Heart disease is the #1 killer. Should we put a pamphlet in with every bagged up McDonald's fast food order? Because that's statistically way more likely in terms of heart disease to kill you. And I don't actually also don't think your data is reliable, as we pointed out.
Well,
It's a-
okay, I think it is, so I guess we'll have
21%.
to disagree on that.
So-
But
so what else?
McDonald's is doing their part by, on their menu, saying how much fat content is in their products. That's a good step and an indication. And I think other responsible restaurants, the tobacco industry has a label on their packages. Now, I don't know if people sees that, but I know that they have put an effort to reduce and to educate the public on deaths from tobacco. And I don't think we're doing that for alcohol, excessive alcohol consumption.
Fair enough.
Yeah, we actually, it is required on alcohol. Yeah, the pregnant women, and then
Yes.
yeah, it's those requirements are on alcohol. So now, Representative Billiam.
Thank you. It's just a comment. I'm a co-sponsor of this bill, and I think it's a great start. I think there is a huge problem in the state with alcoholism, and if we can do anything to educate people regarding the excessive use of alcohol, I think the Liquor Commission and other concerned citizens could come together and find a way to place something in the liquor stores to educate, just like cigarette companies
I
do.
agree. I agree.
Yeah.
Representative Post, do you have a question?
Yes. Would you be aware that since 1989 in the United States, warning labels on alcoholic beverages are currently required to warn of the risks of drinking and driving, operating machinery, drinking while pregnant, and other general health risks, including cancer and colon cancer? That's already on the bottles.
Yes, but I guess it's not working in New Hampshire. So I think a poster in a good strategic place of saying, this is a problem, this is a disease, and by consuming it, you risk your lives, and a possible early death. But thank you for bringing that up.
Follow up?
So a person who knows that this is not good for them, because I think most adults do, and I think even young adults do, what would make them have that effect on them just seeing a poster if they already know that language is, they know that it can be harmful to their lives?
I think it's just the view of the poster and the marketing of the poster. If it's strategic, it will cut to your heart, and you'll say, maybe I have a problem, and maybe I should look in to getting some resources for myself. And I think that is, for the bang of the buck, it's worth seeing something that applies to you. And if you stop to think about it and you say, yes, I do have a problem. Yes, I may only have a glass of wine or 2 glasses of wine a night, but if that's every night, then I have a problem. I'm addicted to this. And it's lowering my life expectancy.
Okay. Representative Burrows.
Thank you for taking my question. I'm going to say, would you believe that whenever I go to a medical appointment, there are posters in the bathrooms, in the exam rooms that say, you know, if you're a victim of domestic or sexual violence, here's where you go for help. So, and I think those are incredibly effective. And I think given that this may have a phone number or a place you can go, this could also potentially help people.
Yeah.
Yeah.
I would agree.
Yep.
I would agree.
Okay. Thank you very much.
Okay, thank you.
So do I have a card from you, Aiden? Oh. Okay. Would you like to offer up something? Okay. Yeah, so I missed this. This is 1624.
Good day. My name is Aiden Moore. I'm the legal coordinator for the State Liquor Commission. And we're not opposed or supporting the bill. We're here. I'm just here to see if I can answer any questions. When this bill was originally introduced, I contacted the sponsor. I contacted the sponsor to try to figure out what it is that he was looking for in his process. And I think what we talked about largely was based on what information do you want to get out and how would you want it to be disseminated. And as a part of that, we talked about posters, we talked about flyers, we talked about a number of things. And as you can see by our fiscal note, each of those comes with a bit of a cost, which is not in our budget. I talked to Graphic Services about a single page, threefold, considering the fact that the bill speaks to liquor, but I'm assuming that that would apply to wine sales as well, because that's not quite in the language. But there were over 10 million individual sales that occurred in fiscal year 2023, 2022, and 2023. So there's a significant amount of manual stuffing of information, putting up posters, and we're not really sure exactly what the information it is that we're supposed to include on a poster. Bill talks about resources, and that was part of our conversation with Representative. Are you pointing them to a certain agency? Are you pointing them to a certain phone number or website? Where are you pointing them? And it wasn't really clear what the sponsor wanted. And I know there are more than one sponsor now, but it really wasn't clear to us what it is that they wanted us to promote. And so therefore, we think that this the concept, certainly the commission is engaged in promoting public safety. We have excellent educational programs that we offer around the state to licensees and civilians alike. The Enforcement and Licensing Bureau is dedicated to making sure public safety is the #1 priority. So we also distribute posters dealing with identification, et cetera, for licensees. So we're not unfamiliar with this type of process, but this seems a little bit vague to us, and especially where there's no appropriation attached to it. It would appear to us that the cost initially would be over $200,000 just to print the trifold handouts. And of course, distributing them is going to slow down some of the processes, especially possibly during holidays, et cetera, where employees are going to have to continue to get these materials, put them into bags or everything that goes out. So we think there are some significant challenges that, if the bill is going to move forward, that we think should be addressed.
Thank you for taking my question.
Thank you.
If we, if a nonprofit would come up with a poster with the Liquor Commission, and there was one poster in each liquor store, just giving people information about where they can go if they have, alcoholic, issues, if they're alcoholics, or, a recovery center, would that be possible? It would just be a poster that we could probably produce with the Liquor Commission and a nonprofit that deals with alcoholism. Would that be possible? We could probably amend this bill to just get rid of the language of this bill and maybe just introduce posters in liquor stores.
Well, I would need to speak with Chairman Malika to see exactly what his feelings are about that. The commission does display a lot of responsible material now in its stores, certainly dealing with underage drinking, et cetera, and over-service. So I think that I'm really not in a position to say yes, but I think I would be happy to bring your request to the chairman to see how he feels about that.
Okay, thanks.
Well, in terms of follow up on that, obviously there was 200 to 450, and you just said that the major cost is probably the three-sided folded,
Right.
color glossy handout. So, did you do a breakdown on when you did your fiscal note? Did you I would assume if we just put posters, 110 posters probably wouldn't cost us much money at all.
No,
Compared to, I would think it's the threefold. So we would save a lot of,
Well, the posters themselves, we talked to Graphic Services, and they were quoting us a figure of 800.
Okay, I didn't see the backside.
Because these would be posted in our liquor stores. So that's a fairly insignificant amount of money, considering it's the brochure and the information included on the brochure. And in some cases, that may be, if that information is outdated or it needs to be updated. Now we're talking about a lot of information which would have to keep track of, even though HHS is part of this equation. They're pretty much sanctioning the message that's being delivered, as opposed to providing what the content would be.
Thank you.
Yeah, I would think that. I know the big push now is 988 for mental health services. That if we work with them in conjunction and put a poster, but it seemed to me you really just can't stop it. But you almost have to have that little holder in the front with a card that you could take with a phone number and with the contact information. But it'd still be a lot cheaper than trying to put something in every package.
Well, this is probably, I probably shouldn't suggest this, but as you know, the commission is introducing its new computer system very soon, and a lot of the information that's printed on the receipts is programmable.
Right. There you go. That's a good idea too.
You could, thank you, sir. Where you could potentially print a message that says, if you need help, call this phone number, etc.
Right.
And now that's accomplished automatically, and it's a
Right.
function.
Then we don't have to
function
think about that. It's already on the receipt. Right.
That's something to possibly consider.
Okay. Any other questions for Attorney Moore? Seeing none? Thank you very much. Is there anybody else who'd like to testify? Seeing none, we'll close the public hearing. All right. So So, is one of many that you will see with my name on the bill, but frankly, I have very little contact whatsoever with what the intent of these department bills. I would say that whether it's liquor or banking or insurance, and in other years it's been securities and whatever. When I bring in these bills are department bills, so they're carrying the flag, and but I'm more than willing to put my name on it too, and that way making sure it gets properly handled, if nothing else. So, good afternoon.
Good afternoon.
Commissioner.
Good afternoon. For the record, my name is Amelia Galdieri, and I'm the bank.
So unfortunately, these mics, you got to pull it and
Gotta
own
really turn it towards me.
Yeah,
Okay.
it's
Is that
pretend
better?
like you're on radio.
Okay.
Yeah.
For the record, my name is Amelia Galdieri. I'm the bank commissioner for the state of New Hampshire. With me is General Counsel for the Banking Department, Seth Zaraki. And in the audience, we also have the Director of Consumer Credit, Michael Poulios. Thank you for the opportunity to provide testimony on HB 1243. This bill was drafted at the request of the Banking Department. It revises RSA Chapter 361A holistically with a goal towards modernizing it and streamlining it and making it consistent with our other statutes. We do have a handout that I think is going around that pretty much covers what Seth and I are going to talk about, but we're just going to go over it in high-level detail and happy to answer any questions that may come up. RSA 361A generally covers auto licensure and regulation of auto financing by the Banking Department. This has been an ongoing effort at the Banking Department to make all of our statutes read nicely, look similar, contain similar provisions, really to facilitate smooth regulation of our licensed entities, as well as to provide sufficient consumer protection. One of the purposes of this overarching rewrite was to try to get out ahead of some consumer protection issues that we had been seeing cropping up. I'd say over the last several years, there's been a moderate increase in consumer complaints filed against auto dealers who facilitate financing of auto sale transactions. And so we rewrote this statute with a goal of trying to get out ahead of some of those issues before they become big issues. In that process, we did an initial draft and then we ran it by the Auto Dealers Association. And they provide us with really helpful feedback. And we were able to work out a few tweaks that Seth is going to talk about that hopefully we can work on as an amendment to the bill as it stands now. So with that, I'm going to let Seth talk about some of the details of the bill and the amendment.
Good afternoon, Mr. Chair, members of the committee. I very briefly wanted to touch on some of the specific changes in this bill to RSA 361A. First, I think most importantly, this reinforces and clarifies the Banking Department's examination authority over retail sellers. Going forward, with the passage of this bill, the Banking Department will include the retail sellers in our regular examination cycle, so they'd be examined once every 2 years. This is designed to ensure retail seller compliance with New Hampshire law. It also ensures regular communication between the Banking Department and retail sellers, so we think this is good for both the business community as well as for consumers. There's some technical changes to the bill, or changes to RSA 361A as well. There are some additional annual reporting and filing requirements which are designed to achieve the same goals in terms of regular communication between us and the business community. The law will now impose a net worth requirement on all licensees of $25,000. There are some other technical changes to clear up some ambiguities that we've encountered in the law over the past years, which have made it difficult for the Banking Department, for the businesses to follow the law and for us to administer the law. And this bill is designed to clear those up. As the commissioner mentioned, we will also be offering an amendment to this bill that we worked on over the past few months in collaboration with the auto dealers. The amendment that you will see is really designed to do 4 things. First, it would revise the effective date of the bill. In the current version, The effective date is July 1st of this year. It would push it about 6 months or 6 months exactly, to January 1st of next year. Both the banking department and the auto dealers, I think, would benefit from that 6 additional months to prepare for the changes that are there. The amendment would modify the definition of significant event that exists in the law. Under the law, licensees would be required to report what are called significant events. So, for example, a significant lawsuit that impacts the licensee's business. And as we worked on this with the auto dealers, the goal was to strike the right balance between requiring licensees to report to us what we think we need to know in order to properly regulate them, but also not placing an unreasonable burden on the business community. The next amendment will be to modify a section of the bill that pertains to the initial license term for licensees. And that's basically a technical change that is designed to align 361A with our other laws that govern our other licensees, and also aligns with the system of record for retail seller licensees, the National Multi-State Licensing System. And finally, there are some technical sort of clarifying changes to the examination section of the bill. The banking department and the auto dealers, I think, spent the most time on that particular section to ensure that businesses know what to expect from our examination process, and to make those changes clear. With that, I'd be happy to answer any questions that you have.
Okay. Can we get
Mr.
Representative
McAleer.
McGinn? Yes.
Thank you, Mr. Chairman. You mentioned considerable consumer complaints. Is there anything in particular that sort of overwhelms all other complaints? Any particular instances or that sort of follow in a pattern?
Trying to think. So consumer complaints are confidential, so I have to tread carefully about what I say. But generally speaking, I think what we were seeing was a lot of educational opportunities where if we had been able to get out ahead of it and do an examination, we could have helped educate the licensee about what our law says, and they could have fixed the problem before it became a big problem. For example, we have a component in our law that requires payoff when you go and trade in a car and get a new car with a loan. The lender has to pay off, or the auto dealer has to pay off the old loan within a certain amount of time. And some people just weren't aware of that component of the law. And if we had been out there doing examinations, we probably could have gotten out ahead of that and done some education. But we don't, the way the law currently sits, we don't do those regular examinations unless there's a big problem that we find out about through the consumer complaint process. So we weren't able to know that that was such an issue. So it was mostly I'd say a lot of education driven issues.
Thank you very much.
Representative Ammon.
Thank you, Mr. Chair. Thank you for coming and testifying. I just had two separate but related questions. Could you tell us about the penalty portion of the law? What's the worst that can happen to a dealer that is out of compliance? And then I'll ask a follow-up if that's okay.
Okay. So generally, I know that it's nearly identical to our other laws. Maybe you can speak to that a little bit more specifically.
Yeah, the penalty provisions have been restructured to align with our other laws, but they really haven't been changed. I would say some of the most severe penalties would be a revocation of a license, a bar from being able to receive a license, and there could be potentially significant monetary penalties, and that depends on the number of violations under the law. So those are the main sorts of, in terms of the most severe penalties, that's what I would consider.
But again, just to emphasize, I don't think that's changing. We just changed the way it's written to make it more clear. And so if somebody's looking at the penalty provisions, they go, oh, this looks just like the penalty provisions in RSA 97A.
Okay.
Yeah.
But over the years, we have instituted restitution, and that you have the ability to order restitution.
Yes, that's not changing. We have
Right.
all the same authority that we do under current law.
But
And just a quick follow-up.
for the question you may inquire.
So separate topic. The proportionality of the compliance burden, and I'm thinking of the largest auto dealer group versus the smallest auto dealer group. Does it advantage or disadvantage one size outfit over another?
Michael in the audience can probably come up and speak to this better than I can, but I'll give it a go. So we tailor our exams to the size of the entity, to the size and complexity of the entity. So you've got a big entity that does lots of business. We might assign 2 examiners to it, do it in X amount of time. If you've got a mom and pop shop that's done just a handful of loans, we're going to maybe do a 1-day exam or a desk review of that. We also have the ability to accept exams from other states and do multi-state exams. In terms of the auto dealers who just do the who just have a retail seller license, they're not licensed in every state, so that's a little tricky for doing a multi-state. But for the big sales finance companies like Toyota Finance, they're licensed in 50 states. So lots of times we can take advantage of doing a multi-state exam or accepting other states' examinations. So we try to tailor it to the size and complexity of the entity.
Very much.
Thank you.
Okay, Dan.
Good afternoon, Mr. Chairman, members of the committee. My name is Dan Bennett with the New Hampshire Auto Dealers Association. We're a trade group for the motor vehicle industry, about 500 businesses, car, truck, motorcycle, snowmobile, ATV, construction, and farm equipment, both franchised and independent in all corners and most communities of the state. So we're here today on HB 1243 to say we support it with the amendment that was just spoken to. We've done a lot of work with the banking department. We'd like to thank and appreciate them for the hard work that went into it. Attorneys on both sides had a lot of back and forth. We think we came up with an amendment that is positive, that's business friendly. We support the need for the banking department to do the modernization. It really does set the bar and also level the playing field. So we think that there's some positive things to come from the amendment. And so, as mentioned, we support both the 35-page bill and the 2.5-page amendment that'll be submitted.
Any questions from committee members? Seeing none, thank you very much.
Thank you, sir.
Is there anyone else who would like to speak? So since we have a little bit of time here, I'm going to use this as an opportunity to tell a story. And that is, story time, because I got time. So at any rate, imagine how long ago this was. Kelly Ayotte was the Attorney General. And the issue at the time was who was exempt from the Consumer Protection Act. Now we had, Brendan Gannon was in here today, talking about the Consumer Protection Act. And in the Consumer Protection Act, we had several exemptions, and we have visited this issue multiple times over the years. I would say the good news is we don't have any bills this year to revisit it again, but we have because some people don't like some of the exemptions. And in those exemptions we have 4, which is the Public Utilities Commission, the Bank Department, the Insurance Department, and the Securities Division. What occurred was that we had a little incident with an auto dealer who argued that they were exempt from the Consumer Protection Act because they were the banking department. They were registered to do financing, and they had a little parchment on the wall that says that they're a licensee, and so they thought that they could get license out of it. It was quite a struggle, and but we were able to stick in the consumer. So if you ever look at the Consumer Protection Act and on the exemption, you'll see the last sentence says, except auto dealers who have this license due to the financing. And so the reason why I think it's important for everyone to understand is that what we ended up doing in that consumer was to solve the whole thing of the exemptions of the Consumer Protection Act was the power of restitution. And that is that the banking department, insurance department, at the time did not have it, and we were able to give it to them, was that they can make a consumer whole. If a consumer's been harmed, then make them whole. And so, yes, in the same case with an auto dealer, if there was a problem with the financing, obviously if it's something related to the car or those other things, there's a separate statute related to all that. But more importantly, these 4 exemptions done under the Consumer Protection Act, all of them have what the Consumer Protection Act has, which is the power of restitution. And so it made the consumer whole. And so I'm just saying this because I think in terms of globally trying to understand what we did, because we had all these bills related to Brendan was here, and we related to the Consumer Protection Division and what its job and what its mission is, which is that power of restitution, is to make the consumer, make the New Hampshire consumer whole from whatever happened, whatever in terms of the transaction. But this is something that's been on the books for a while, and it's worked really well. And I think that we have a great situation in terms of how we understand where the Consumer Protection Act begins and ends. So that was my 5-minute story. All right. So we have another 10 minutes, and then we're back to liquor. There's another story. We haven't had any sign-in sheets.
Well, I picked one up earlier.
I didn't sign into anything yesterday. No. Very important. If you want to get paid, you got to do the machine downstairs. So this sheet here actually never leaves the committee room.
Oh, okay.
And it's supposed to, so that you could, if people wanted to see whether you were here today in the committee room, then you could have signed in and never showed up to the committee room. So, but it's true. I haven't signed that. I don't think Leif's. Yeah, well, that's right. Yesterday would be the first day. So, but thank you very much, Commissioner. Yeah.
Harry was quiet this morning, wasn't he?
And he's gone already. Come and gone.
Yeah.
Just me. He was a young guy. He is an individual. Private citizen. Good. How are you? Good. Are you? Exactly. What did I just say? What did I say? Oh, nothing. You're not sure. That's been mentioned. Yeah, I told them the young private. They changed the law 5 years ago. They just had to pass it. Where you put that jurisdiction. Right now. This one has Oh, you're gonna step it. So it's on a dead end street. It's got a bit for everybody to see. Oh, it's beautiful. I mean, it's really quite nice, kid. Where's this down? Where's this trip? This place, the golf trip we take. Yeah. And these guys got an Airbnb. And it's quite nice. It's like $2 a night. Of course, people are. It's getting like a metro area for Austin. It's just another hour more and then it's still driving home.
Okay, we'll open up the public hearing on House Bill 1227 and hear from the prime sponsor, Representative Jessica Grill. Welcome to the Commerce Committee.
Thank you, Mr. Chairman, and thank you to the honorable members of the committee. As the title suggests, HB 1227 extends the time that alcoholic beverages can be served on site from 1 to 2 a.m. statewide, and it also enables cities and towns to authorize a 3 a.m. limit if they so choose. This bill will give bars, restaurants, and event venues more freedom to serve their customers, expand nightlife opportunities, and encourage people to patronize New Hampshire businesses. Currently, we have one of the earliest statewide closing times in the country. Most states set a 2 a.m. last call, including many states in the Northeast, like Vermont and Massachusetts. And allowing municipalities to approve a 2 a.m. last call in 2013 was a step in the right direction. However, there have been no changes to the law since. HB 1227 will align our liquor laws more closely with our neighbors and will make our state more competitive. For example, someone might be more likely to choose New Hampshire as their destination for a corporate retreat over Massachusetts or Vermont. With more young people looking to build their careers here and tourism being such a large part of our economy, it's past time to take another look at closing time. Another benefit of this bill is local control. Many of our cities and towns, including Berlin, Nashua, and Laconia, have already opted to set their last call at 2 a.m. under current law. Giving them the option of a 3 a.m. last call will give them more flexibility. A city could enact an ordinance authorizing a 3 a.m. last call for special events like New Year's Eve or the 4th of July, much like how Laconia currently allows alcohol to be served until 2 a.m. during Bike Week. To address some public safety concerns, I'd first like to speak to the issue of drunk driving. When the RSA was last updated, customers had far fewer options for a safe ride home than they do now. As ride-sharing services have grown and state agencies have invested in educational campaigns, New Hampshire saw a 13.9% decrease in drunk driving deaths per capita from 2010 to 2019. I also want to call out that while we did unfortunately see drunk driving increase in 2020 and 2021, this was during a period where bars and restaurants were either closed or had very limited service, which indicates that there are other factors at play besides bar and restaurant closing time. While you may also be worried about potential increases in overall crime, a 2017 study showed that increased foot traffic is linked to lower crime rates. Although correlation does not equal causation, and we've seen other study results are mixed, this suggests that residents and visitors are more engaged with their communities when commercial activity is present. Additionally, allowing bars to serve drinks later is not a permission slip for unsafe and illegal behavior. Vendors can and should still be held responsible for over-serving their customers, serving alcohol to minors, or allowing other unsafe behavior on their premises. We must continue to empower our local police to enforce the laws and keep our communities safe. Essentially, this bill is about choice. It will expand commerce for businesses statewide while giving cities more options to meet the needs of their residents, whether that means keeping last call at 2 a.m., extending it to 3 a.m., or doing so on a permanent or temporary basis. If a business owner doesn't want to stay open that late, they won't be required to, just as they can close earlier than 1 a.m. now. HB 1227 simply puts more control over closing time where it belongs, in the hands of local communities and the businesses that serve them. Thank you. I'm happy to take any questions.
Okay, I guess that's a pretty straightforward bill. Representative Billio.
Thank you for taking my question. Have you talked with bartenders about this bill?
Yes, I have.
And in general, they're all in favor?
From the ones I've spoken to, obviously limited sample size. I haven't been able to survey every bartender in the state, but the ones I talk to are excited about the opportunities for more revenue for their businesses, more tips, frankly, and helping increase that foot traffic that brings in money.
Just a follow up. So if there's a bartender that really can't, work until 3, but the restaurant owner wants the restaurant to be opened up at 3, it might cause some issues with some employees. Maybe, maybe not. I don't know.
I definitely think that's a valid point, and that's an issue that's not uncommon in the restaurant industry. I think scheduling conflicts are always going to be an issue. There's people who prefer to work the night shift. There's people who absolutely can't work the night shift. This bill doesn't address any of those concerns. I I unfortunately can't speak to the specifics there, but I would encourage, bartenders who are concerned to speak with their managers and try to work out a schedule that's a better fit for their own needs.
Representative Patusek.
Thank you, Mr. Chairman. Thank you for taking my question. Has the Restaurant or Hospitality Association been contacted about this bill?
See, he's got his pink card in his pocket.
I have not had a chance to speak with them yet, but it looks like they're here.
Any other questions? Okay, get off easy. Oh, no, Representative Gibb.
Thank you, Mr. Chairman. Thank you, Representative Grill, for taking the question. Do you have any data on does drunk driving increase after a certain hour of the evening? Likelihood of drunk driving deaths or injuries or whatever after 2 a.m. or whatever?
I did some research through the New Hampshire Department of Transportation. Unfortunately, I wasn't able to find any time-specific data for New Hampshire. I've seen studies nationwide, and those have seen mixed results. Some other states and other countries as well have seen increased drunk driving incidents late at night. Some have seen decreases. So it was unfortunately impossible to draw a clear conclusion of the relationship between the two.
Okay. Everybody else had? Okay. Thank you very much. Is this your other person? Okay. So Chair will call on Michael Strand.
Schedule the last couple days. I wasn't able to stay late enough to testify for the PFAS.
Yeah, right. He was making a PFAS joke, so it's good. Now you can turn your mic on.
Hit the button.
Oh, we're on. Okay. How about that? Appreciate the opportunity to speak today. My name is Michael Strand. I am a Bedford Town Councilor. I manage a small business in Bedford, and I am a dad, I guess would be the qualifiers. I think this bill is really common sense, in my opinion, and I'll explain why. Admittedly, I'm not going to admit my age here, but as somebody with a 10-year-old, I don't get to spend a ton of time out at bars or engaged in the best of what Manchester or Portsmouth, nightlife has to offer. But I do know plenty of people who work in the service industry. I am speaking in favor of this bill as well. So I did myself for years work in the service industry, sometimes as a second job, often as a first job. And I'll tell you that along with, the bill yesterday that I could only submit written testimony for, and I hope you read it. I think this is a common sense, pro-business, apolitical, bipartisan bill. We all work or did at some point in our lives, right? So my question to this committee would be, what's an hour worth when we talk about extending, sales of alcohol? More importantly, what's an hour worth when your hourly wage is plus or minus $5 an hour? You rely over 90% on your tip-based sales revenue, of which your employer takes none because they got 100% of the gross margin on your sales minus wages. And more importantly, you're a bartender. So, I think, serving the highest demand product since the beginning of time in the only privatized direct service retail setting where you can capitalize the sale of that product without government intervention is a relevant thing to talk about or think about. In short, you sell liquor, beer, and in the only place you're allowed to sell it and get tipped for your services. So I think when we have these broader conversations about, the role of government from a macro standpoint or the impact on business and individuals, we kind of live in a funny state sometimes, don't we? We're talking about the last hour, last call, the final two rounds, when responsible best practices, with regards to avoiding, over serving our employed. But this is the best time to sell your product. It's the best time to make money, pay your bills, support your family, and, live free without having to die for it. Live free or die is kind of our funny way of framing policy in many cases. It's a turn of phrase capable of encompassing all manner of evil, or, in this case, I think good. This is about the freedom to work, in my opinion. If the concern is public safety, I'd have to try not to laugh, to be honest with you. I actually pulled some, ancillary data regarding differences between DUI charges, death rates per, capita, and matched them. I'm sorry, Mr. Chairman, am I boring you? Oh. Oh, okay. I apologize. There's actually no identifiable correlation between states that close at 2 and higher rates of alcohol-related crime from a first glance. I'd encourage you to do a deep dive, but particularly in this state, we're a small state. We have a great law enforcement community, and I think we do tend to respect each other's rights and act pretty responsibly. I don't view that as any increased, public safety hazard. But I don't even think we should have to talk about that really, because, having a conversation about whether we should regulate, cutoff times, it's going to defer to the choice of the business owner anyhow. And really, to zoom out for a second, the government pre-regulating businesses or individuals, commercial rights out of speculative assumption regarding individual New Hampshire citizens' behavior is just not a winning formula. It's like regulating pre-crime. I wouldn't do it. I would even potentially make the argument that to not put this bill on the floor with an ought to pass, could amount to, however unintentional, legal discrimination against a whole class of workers in the Granite State, inhibiting their ability to do business, support their families. So to me, this is an easy one. I'm happy to take any questions, but I think, it's apolitical and it's an easy move to deregulate and help business and people.
Just ironically, that the argument was when we changed it to 1, it was 11. And
Oh, was it?
That was the argument of why we needed to go to 1, was to give the person who had the second shift to.
Interesting.
So
I guess
now you're going farther out. You're now deep into.
I didn't realize it was 11. That's pretty crazy.
Thanks for taking my question. This is more of a would you believe. I live in Bartlett, which is a more rural community, and we do not have ride services like Lyft and Uber. So would you believe, I do appreciate the fact that you're leaving this to local control, because I have a real concern about people not having a ride. We have more moose and deer at that hour than we do people, but I also want to protect the wildlife. So I appreciate that it's local control.
Sure.
Well, I want to protect people too. I'll say that.
Okay.
Yeah,
Representative
I
McGill?
Thank you, Mr. Chairman. Mr. Strand, did you say that you don't believe there's any correlation between more accidents from DUI, and would you believe that the prime sponsor testified to the contrary just before you walked in the door?
No, I did not realize that. I just took a rough correlative glance at, different states and what the rates were who had, on average higher, or later, times that they served. So I just, again, I frame that argument in the fact that I don't believe we should need it, because I think, that's an overstep. I mean, what individuals choose to do, whether right or wrong, that's a separate criminal issue. It's a separate legal issue. And, I don't know that this body or we have the purview, to legislate based on what could happen. Again, it's legislating pre-crime, which I fundamentally have a little bit of a problem with, It's a slippery slope.
Yes, Representative Leo.
We deal with a lot of liquor bills, and if an individual is in the restaurant or in the bar, and they're there until 3:00 in the morning, do you think they're going to be drinking more because they have one more hour, or less, or?
Yeah, I think that's where you're going to get a high level of variability across, across different businesses, based on policy, best practices. I mean, there's pretty stringent guidance on, not over serving, which I've, I don't have a ton of experience, seeing this, but I know, at least in our area, restaurant owners and folks who are concerned about their own level of exposure or liability are pretty, pretty attentive to this. And I don't know that it'd be 3 a.m., but I think typically, if you extend it to 2, you would have things winding down long before 2. I don't think people would be there until 3. I think, also individual common sense, people who work in the industry have had plenty of experiences, good, bad, and ugly, and they are going to be proactive in terms of making their own lives safer and easier as well. So, I tend to trust individual business prerogatives here and individual people.
All right, thank you.
Yeah.
Okay, so before I let you go, and that I've been around here a long time. I was here when we changed it from 11 to 1, and we did have the discussion at that time about leaving it up to different towns and letting them. And the reason why that didn't make it was the concern that it's spot, that we would call spot zoning spot, so that if one town say really adamant, they don't want anybody driving through their town after a certain hour.
Sure.
But this other town next door does pass it, and they're upset that now everybody's driving back and forth and if they had consumed too much, then it creates a hazard to their community, and that's why we ended up not doing that last time. Right, the neighbor. So
I think that's a fair concern, particularly when we talk about one community's ability to negatively impact or infringe upon the rights of another, assuming we go back to a local control model. But I mean, I think you can see this sort of nuanced local legislation, both in the state and nationally, even when you go back to coming out of prohibition years and which counties and towns were dry and what time, they could sell retail. Obviously in New Hampshire, it's different because, the state runs retail liquor sales through the stores. But, we're also making assumptions here that, and yes, people make mistakes and drink and drive and often pay the price and unfortunately do hurt other people sometimes. But people shouldn't be drinking and driving, period. So to try and, curtail, rights in one regard, to prevent other crimes from happening. I mean, we could run that experiment up and down government and have quadruple the laws that we have. And I don't think that's the answer. I mean, people shouldn't be drinking and driving, period. They shouldn't have 2 and drive. They should make reasonable accommodations. They should have a friend
should we
who
mandate that there be a designated driver?
I don't know how you'd enforce it. Talk about inexpedient to
Well, you get
legislate.
pulled over and there isn't one, then they're going to get busted.
For sure. Well, and I'll say this, living in a community that is very much historically was, a crossroads, to the state, and certainly is now, if you ever drive down 101. I also tend to trust, call me naive, but I trust law enforcement. I think they get a lot of these folks who are not following the law. And when you combine that, pretty strong guardrail, which is there for a reason, and existing laws around consumption, from public intoxication to, driving while under the influence. You combine that very broad guardrail, which I think is effective, both in terms of catching those who do it and, being a clear signal that prevents people from making the wrong choice. And you combine that with good common sense that people don't want to kill themselves or others, and they have friends who might be willing to, to start drinking water for the last 2 hours or whatever the case may be, or not drink at all. I don't think that there's a need to change sales-related business policies as a result of fear over this.
Okay. Thank you very much.
Okay. Thanks for your time.
Okay, I have 2 cards left, and we have enforcement and deputy enforcer. Are we doing it separately, or are we doing tag team? Yes, come on up. So,
Every time
Mike,
you
are you going
stand up,
to
the
want to
bell rings
testify,
in the
or you
chair.
want to listen to hear what they had to say? I used to give Jim Demers a harder time when he would do that to me all the time. Okay.
Thank you, Mr. Chairman and honorable committee members. Again, for the record, my name is Mark Armaganian. I'm the Chief Enforcement and Licensing for the Liquor Commission. Also with me here today is Deputy Chief Danielle Elston. And we will probably pull at Danielle's previous job being field commander for the field area. So the way we look at this, first of all, I thank the representatives for what they have put together as a proposed bill. At the same time, I think there's we're looking at this from an industry standpoint, and I think we need to look at this from a safety standpoint and a law enforcement standpoint also. You brought up a very good point, Mr. Chairman. This is going to be looked at, as all of you know, and most of you know that have been here a while, 6.5 years ago when this administration got together in enforcement, we only regulate to the level of community and industry safety. We believe that there should be local control, and this issue specifically has local control attached to it. And Danielle will be able to speak more about how only 3 jurisdictions in this whole state have actually pulled at that availability that you mentioned, Mr. Chairman. In speaking to the chiefs, even if we take let's say we take Hillsborough County, because most of the sponsors are from the Hillsborough County area. We're looking at 32 municipalities in that area. Out of that, two-ish cities, maybe 3, depending on how they're established. And we have an unfunded mandate. Once you create longevity with hours of service, enforcement has to be out longer. You have the unintended consequence of the jurisdictions that don't want this to happen. They have to put resources on the road. And I feel that this is a burden that's going to be put on the taxpayer at the end of the day, which we've always been looking at this as saving resources. We have an industry that shuts down at 1 o'clock, drinks off the table by 1:30. If they extend service through either their municipality or through us, we're looking at an extra hour on that. So we know what the stop is. I know how long that we have to create coverage. And I would hope at some point, but good people make mistakes, as was stated, that everybody acts appropriately and service is done appropriately, and it doesn't always happen that way. That's reality, and that's why we exist. So with that in mind, I'd like to give the floor to Danielle to speak further on this.
Good afternoon. So I think it's important just to point out the law as it is right now. The law right now allows licensees to sell till 1. Patrons can consume their alcohol till 1:30. There is the provision in the law that allows the local municipalities to extend the service till 2, which allows patrons to drink until 2:30. Only 3 municipalities in the state have done that, as stated by the sponsor: Berlin, Laconia, and Nashua. Laconia's provision is limited to the Wares Beach area. Nashua's provision is limited to only those licensees that also hold charitable gaming licenses. So we don't see this as a significant push throughout the state to move the hour until 2 o'clock. And like the chief said, there's also a provision that allows licensees, if there is a specific event where they wish to extend their hours, they can do that through the commission, and the commission can grant that exception. We actually have a significant amount of licensees that do this during New Year's Eve. They request to extend their hours of service for that day or for a particular event. So that provision is also already in the law to allow for that.
As I mentioned earlier, I think also that, and I know Beth was here earlier, the chiefs of police, specifically one of the largest jurisdictions being the Queen City, Manchester, the chief would actually be here stating the same thing that we are. It's just, it puts a burden on resources that would actually have to be relayed to the taxpayer. It's more people on the street, more police officers on the street, more enforcement investigators to actually make sure that our mission, keeping this industry and the community safe, is adhered to. And we're open for any questions.
Do you, knowing in each community which establishment is going to take advantage of this, do you then stick around all the time to that closing hour?
And we do after hours checks to make sure that they're closed.
So maybe there should be an added fee. Maybe we should, have a license to stay open later and to offset our state costs to have enforcement there.
That as always, we remain neutral on these suggestions that are brought up by this committee. But one thing I did want to mention is in that jurisdictional area, the county, let's say of Hillsborough, we have 530 licensees in that county through those jurisdictions. I couldn't tell you what the number of not only traditional law enforcement, but liquor investigators there would be to actually have oversight of this, because know that when people are letting out of these establishments, they find other establishments to go to, like breakfast establishments and places that don't sell alcohol. So this extension of hours will now go into the wee hours of the morning. We're looking at if it's 3:00 with drinks off the table at 3:30, we're looking at 4:30, possibly 5:00, and now we're 24-hour coverage. So we're coming here for more manpower and going to fiscal. I like the idea for commerce, but the negative outweighs the positive in our view.
Okay. You got one more point?
One more point. As we run into now with the current law as it is, we would ask if this does move forward, that there is a requirement for the local jurisdiction to notify us that they have extended the hours. That hasn't been the case in the past, so we usually find out through the newspaper or walking into the establishment. So I would say if this were to move forward, we would request at least a notification to us so we were aware that that municipality has extended their hours.
Okay. Yep. We do have another question. Representative Evans?
Just a quick question. So the current statute as it stands, it says the licensee may sell until 2 a.m. under conditions authorized by the legislative body. I think I just answered my own question. So the legislative body locally can put conditions. You mentioned Wares Beach only,
Correct.
or betting casinos in Nashville only.
Correct.
That would be a condition that, okay, thank you.
Okay. We're all set. Thank you. Sebastian Fuentes, who's in support of the bill. Right. Who do you
Good
represent?
afternoon.
I see you have an orange bag.
Put the mic on there.
Yeah.
My apologies. Good afternoon, Chairman. My name is Sebastian Fuentes. I'm the political director for Rights and Democracy of New Hampshire. I'm not here representing them right now. I saw the bill and the importance of the bill, and I just felt like a little bit of my work experience might be able to give I can give you good feedback. I worked for 18 years in the hospitality industry in the food and beverage. I was a director of events, banquet captain at the Omnium Washington Hotel up in Bretton Woods. Also at the Mountain View Grand in Whitefield, New Hampshire, doing banquets events for about 18 and 19 years almost. So all I want to say is I discussed this bill with a few of my current friends that are still working in the business, and what they asked me to kind of present to you is like a few of them, especially in the management world, that they really agree with the concept of this bill because they want to make sure that they increase the sales. Now, with that said, excuse me, there is a lot of ongoing already training going on in these premises. I was team trained certified for I think 12 years to be able to provide the best management of the alcohol sales to our patrons. Another common occurrence that happened to us while working at the hotel, especially doing weddings, because we end so early, many of our the clients, the guests, will go somewhere else to find alcohol. So what this bill maybe implicitly try to help us is to be able to keep all those folks in one place, to be able to monitor it better. We have a lot of instances where they go off-site, they go drinking on their own, and that's when a lot of those issues with the local law enforcement happen. It happened to me many times in both of those properties, and it is really important that we also take in consideration that these places put a lot of effort into training. I'm just speaking for those two properties. I'm pretty sure that happens all around the state, but they would like to be able to. You guys consider this bill for to be able to keep more businesses, to keep business in New Hampshire, because a lot of those guests they come out of the state. They look at our liquor laws and says, "Hey, you guys are closing too early. We're not going to come here." It happened many times too. So I just want to kind of see if you have any questions. I know Representative Bolio asked about if you talk to a bartender. I have myself, and a few of them are in support of this bill because it will increase their the amount of money that they bring home, because they want to make money. Serving alcohol is definitely how they do it, but at the same time they want to do it in a responsible way that be able to put our guests, the clients, the patrons are safe while also bring some money to their home. So I just want to kind of, if you have any questions, I'll be more than happy to. Hopefully, some of the experience I have in that field might be able to.
Representative Burrows.
Thanks for taking my question. You mentioned that, you worked in Whitefield and
Yes.
Bretton Woods.
Yes.
And patrons may go somewhere else. I just looked, there are no bars in Whitefield that are open after 8 p.m. And I don't know of any bars in Bretton Woods that might be open after 1 p.m. I mean, there's just nowhere to go.
My apologies. There are bars open in Whitefield later than that. We have a few in the common area of Whitefield. They're just brand new. You might not have it on your list,
Okay.
but there's some in there. At Bretton Woods, what happens is many of those guests, they come, they know they're staying for a couple of days, so they bring their own alcohol with
Yeah.
them, and they go to the rooms.
Right.
And they just they just stay there longer than expected, but it's hard for us employees to monitor what's happening in those rooms.
Sure.
It's not really. We're not gonna knock on the doors every single time, say, "What are you drinking?" Or if there are underage people drinking in those rooms, that's something really that is extremely hard for us. But by doing it, maybe by passing this bill and extending the hours of service, might be able to contain them in the banquet venue. We might be able to have the bartenders, the bar backs, and everybody else is working, including the captain and management, to be able to watch them more closely and keep an eye on them.
Thank you.
So what time does the Omni close now?
The Omni close.
Yeah.
I've been out of that business for about 2.5 years now.
Yeah,
I don't know if they
okay.
changed times, but when I was there, last call, usually they have an underground bar, ends at 12:30.
The cave. Yeah, we all been in the cave.
The cave, and then 12:30, last call, 1 o'clock drinks of the bar, and that was still fairly early.
So they could take advantage of the current law and extend it, but they've never gone to the town and Bretton Woods and asked them to get that extra hour.
I think that's kind of like just internal management. It's kind of like a corporation as well. So they run things differently.
Well, see,
I
I'd
don't know.
venture to wonder is maybe, how about the Whitefield, was it the Grandview, right?
The Mountain View Grand in
Yeah,
Whitefield,
Mountain
yes.
View, yeah, Grand- So what time do they close?
The same hours for events.
So
and I'm just talking
they
about the
don't-
events,
they don't
not for the
wanna stay
restaurants.
There could be a possibility that these people are pretty happy closing when they're closing now, and they don't really want that extra time.
I can say for experience that that wasn't the case many times. They always want to extend the hours. They also wants to, they feel like because in other states around us it's a little later, that they feel that they can do it later. When in reality that's not the case in New Hampshire. We have to enforce what the laws are.
Right, but the law says they could stay open till 2:30.
Right, but that's
They haven't chosen. So I'm
experience.
playing devil's advocate with you.
Right.
I'm saying is, gee, the law already allows them to stay open later. Why would we need to pass this when they're not even willing to take the law that we already have on the books? Then maybe they really don't want to stay open later. Maybe they really don't want to keep their employees around longer. Maybe they're at that seems to me that we did find the right spot, given that that's what time they're willing to close at right now.
I think that'll be. I would love to have the management team from any of those properties to come in and testify on that. To be honest,
when you see them, urge them to send us letters. We won't
Absolutely.
be taking action on this mill in
I
a
would.
couple of weeks. So, flood our mailboxes with internet mailboxes with telling us to convince that there's a great demand for this.
you can all visit the North Country and stay at those beautiful hotels as well.
I stay at the Notchland Inn.
Yes, yes.
And I'm very upset with the Omni because they won't serve me dinner because I'm not staying at the hotel.
Oh, wow.
So I'd love to be able to stay there, but they won't let me stay there for dinner. But I have been to the Cave, and I would say that those big hotels would be the ones who you would make sense to be open to stay up later, and that's why I'm kind of shocked that they haven't taken advantage of the current law.
I think that's based on every special. Every client is different. Every client decides how long they're gonna serve, and that's just the specifics of each client.
Okay, thank you very much.
Thank you, Chairman. Thank you.
All right, Mike. And I would say you're going to be the last card, but Amanda's put her card in, so she's going to respond to whatever you say.
Do I dare? Okay. So I was going to hold my remarks until the work session, as this committee loves to do work sessions, but I guess I'll jump in now. Just for recognition, so my name is Mike Summers. I'm the president and CEO of the New Hampshire Lodging and Restaurant Association. We have about 1,300 restaurants, hotels, and other attractions, et cetera, as members from all over the state. My experience in the industry directly was not as long as the previous speaker. I was only in the industry about 15 years, but I worked everything from a dishwasher to the general manager. So I've tended bar, I've waited tables, I've done all of it, certainly been there and done that. Normally, I would be up here testifying in wholehearted support for something like this, as it's less of a restriction on businesses. But after speaking with our board and our membership, we did kind of a straw poll survey last week, and not knowing where everyone would be, we kind of came out with a somewhat of an unofficial position. We won't adopt it till next week, but at this point, it looks like we're about 60 to 40 opposed to this bill. I suspect, and again, looking at the businesses that responded, the late night drinking places where hospitality employees love to frequent, very supportive of this. But then many restaurants, hotels, and other actually weren't, which kind of surprised me a little bit. And I think to your comments a moment ago, Mr. Chairman, I think a lot of these hotels closed down because more than anything, staffing issues. They don't want to stay home any later because they can't cover it. I will also, I do want to echo the last person who testified, these comments on training. I think our industry does an exceptional job in training. Again, it's not 100%, but it's a pretty high bar. Many of these businesses invest a lot of time, effort, and resources making sure that their staffs are trained appropriately, visible signs of intoxication, what constitutes overservice, those kinds of things. So I just want to make sure we put that on the record. But I think that this is a rather complicated issue for the industry. And it really gets down to it's not just about it's an extra hour, it's more sales, because it's much more than that. Under some of the licenses that these businesses carry, they're required to have food available while these alcohols are being served. So then that's not just a couple of bartenders. It's you got to have at least one person in the kitchen. That person has to be ServSafe trained because of the person in charge rule under the food safety rules. You have to have the equipment turned on. You have to have the hood system running. So it becomes ancillary costs that are attached to that. And one of the ancillary costs that I think we often forget in these discussions is liability insurance, which comes up more often than we care to admit. But I think that right now there is some flexibility in the system where municipalities can already adopt the 2 a.m. I don't know that 3 a.m. is a necessity for New Hampshire, but certainly open to the discussion when we get to a work session. And I think the other one that's worth noting too, in some of these more built-up areas where you might actually find ride shares, there becomes a staff safety issue about, folks walking out of a bar with a pocket full of cash at, 2, 3, 4 o'clock in the morning. So that certainly was mentioned. But I will say that in our straw poll survey, the number one comment that we got back from all the members opposed to this was nothing good happens after midnight. So I'm sure we've all used that phrase. I know I've certainly heard it. And I would also just echo a comment from Representative Burrows about rideshare. Rideshare might work in Manchester. It works in Boston and other major municipalities. It doesn't work anywhere outside of those kinds of areas. Unless you have a significant rural buildup, there really are no rideshares. So the later you go, I think to Representative McGo's comments earlier, I think that you do raise the risk and hence the increase the liability insurance exposure for these businesses. With that, I will stop, save it for the next work session, and happy to try to answer any questions.
Thank you very much.
Good?
It's great.
Thank you.
Okay, Amanda, now you get the last say.
Been a minute since I've testified on anything. I just came to watch, but I thought I'd make a couple of points. I'm Amanda Bolden, rep from Manchester Ward 5. There's, when it comes to selling more alcohol, more food late at night, there's more meals and rooms tax coming with that. So it's not like the expense of enforcement just goes up in a vacuum. There's benefit to the additional late night sales. Also, just did a little Google, and it looks like only like less than 10 states in the country don't have a 2 a.m. last call. The vast majority do. Alaska has a 5 a.m. last call. I don't know if that's because of how little sunlight they get. Maybe they have like a 6 p.m. last call at other parts of the year. I have no idea. But and interestingly, Vermont has a 2 a.m. last call and has fewer drunk driving deaths than New Hampshire. And I think it's worth noting, that it is, since none of us are data scientists, it probably would be extraordinarily difficult to draw any links between any one policy and the other. But it certainly seems pro-business and pro-worker and pro-commerce. That's the name of this committee, right? To pass this legislation. So I think those were the only points that I thought might be helpful to interject into the conversation, is that Vermont has better hours and fewer drunk driving deaths than we do, and something like 30% fewer, and that when you sell more booze
I
and
assume
more
that's on a
food,
per capita basis. Because they're a much smaller state than we are.
no, it's no, I think that's just the bare numbers, yeah.
Okay,
But
so
it's like
you gotta do it
30%
per capita.
less.
Yeah.
Yeah, I didn't
And-
really feel like getting out a calculator and putting all those zeros in.
Yeah, it's-
But you can Google it too. But then the other point being that there is a benefit to the economy in New Hampshire when people can engage in commerce for longer periods of time. Thank you. I don't want any
We do have a
questions.
question. We have questions. Representative Am.
I know we're at the end of our day here. Thank you for coming and testifying.
If your question is, am I going to go to a bar? It's no. I'd stay at home.
Oh, no. I could make a joke on what you just said, but I won't. So would you believe that this legislation could be considered anti-discriminatory? And the reason is because people have different chronotypes. So chronotype is when you're most alert, when your circadian rhythm is most alert. And there are night owls, we've all heard of night owls, and there are morning larks, people who get up early in the morning. And there are, I think finches are people that are midday active. And I think that this society discriminates against the night owls because And so this,
Representative Ammon, I would believe that that's a terrible argument, but I also want to know which one are you?
I'm the night owl.
That tracks. There might be a real question.
Yes, Representative McHugh.
Thank you, Mr. Chairman. It's kind of a clarification. So this is something I've been keenly aware of since, working the streets as a medic, picking up enough drunk drivers and things. Would you believe that Vermont is the 4th worst in the country for drunk driving deaths?
No.
And that's the per capita.
Do you mean on a per capita basis? It's
Correct.
interesting
They're
because
the
I
4th
did
worst,
I
and
did
New
look
Hampshire
up
is better.
the rankings and by per capita and on the bare numbers, and I didn't see that.
All of the above. They're also 600 and change thousand.
I mean,
we're
imagine the
1.2 or
distance from one
1.4
bar to
million.
another in that state. It could be 2-hour drive. So
Yeah, it's imagine that. Imagine that. So
I
they're
think
one of
it's-
the worst in the country.
I think if
not
the
a good
committee
example.
wants to put effort into trying to draw delineations between different sets of statistics, it's worth your time, but it would take a lot of time because I don't think that it's easy to just draw conclusions based on a limited set of information. I think it's really complicated. If it wasn't complicated, we wouldn't be sitting here. Someone else would do this, someone who gets paid a decent amount. Not $100 a year. Maybe they'd be getting like 120K and they'd be really smart and they'd figure it out. So
Well, you get the perks like I got,
I think I'm getting $20 in mileage today. So
Representative Close.
Yes, thank you for allowing me to ask a question. Is this mandatory for every restaurant that they have to be open till 3 o'clock in the morning, or can they make those choices for themselves?
that's not my read of the legislation. I'm confident that it is up to the individual business. There's definitely places I wish I could visit that aren't open as late as I'd like.
Thank you.
It's I would say I have a wide selection of liquor at any time and you can have, but no, some towns do just
I wouldn't-
they're the operators in the town, and I think it's the employment problem. They just don't, the people who are the bartenders are not college students, even though we have a university in Ringe, but they close up at 10.
Is it not the case that there is a bartender co-sponsoring this bill? Do I understand that correctly? Two bartenders co-sponsoring this bill,
Right.
which says so much about the legislature in New Hampshire, but also about this bill.
Right.
Yeah, different things.
So, okay, we all set? Everybody all set? We had our giggles? Okay. Thank you very much. All right. With that, we will close the public hearing and to do this all over again tomorrow.